Very well. Then
Learned counsel, this cannot be. This cannot be. He is taking a week, and you are taking a further week.
let me
Fortnight
finish na. তুমি তো
cannot be
থাকবে।
counted.
তুমি তো থাকবে। Let me finish. He will do it on the next week. So if your lordship kindly takes it up next,
Why not? Why not on Wednesday?
it would be perhaps for us to get ready. I understand, because your lordship was sitting on Fridays. Last Friday, your lordship did not sit. So he was to complete, and thereafter I was to argue. Your lordship gives me this weekend. I will definitely be ready. Kindly takes it up next week, Tuesday, Wednesday, anytime. If it could be at 12.
Why not Monday?
It can be Mondays. Usually, sometimes there are matters which are fixed. That's why Tuesday at 12 or 12:30.
Tuesday at 10:30.
At 10:30, your lordship understands sometimes the motion benches are there. I do not wish to embarrass your lordship. That's why.
If any matter is taken up, let us say a second appeal is taken up. It cannot be.
Can it be at 2 then? 10:30 is sometimes, as your lordship knows, sometimes bails are fixed and all that. That's why I would not have troubled your lordship otherwise. Any day next week.
(17th) Monday at 2 p.m.
Very well.
Learned counsel.
The appellant has expired.
Yes.
The lordship is aware of it. So,
your learned junior had commenced, and he had
yes, he has placed for about substantial part of the evidence. I'll just wrap it up before your lordship. তুমি আমরা সেদিন নোটসও দিয়ে দেবো, তুমি
যেটা বুঝতে পারবেন না সেটা ক্ল্যারিফাই করে নেবেন, ঠিক আছে? আপলোড যেন পারফেক্ট হয়। চলো ওনার নাম নিয়ে নেবেন। learned counsel representing the petitioner seeks an accommodation for a week. Full stop. Accordingly, let the matter appear on 17th of August 2026 at 2 p.m. Okay, on consent of both sides. On consent of both sides, let the matter appear on 17th of August at 2 p.m.
My lord, item number 2, my lord, I'm paying for short password, my lord.
Let it be called. Let it be called.
My lord, item number 2, I am the respondent number 124, my lord. I'm paying for short password, the arguing counsel in court number 37, my lord.
Mr. Srivastava.
Short password.
Up to your lordship.
Din. You are representing
124, my lord.
124.
Arguing counsel Mr. Mukherjee, my lord, in the court number 37, my lord. I'm paying for short password.
What about the opposite parties number 5?
My lord, all are coming, my lord.
5A.
5 and 6, my lord.
5A and 6.
My lord. Sumitabo Chakraborty, my lord, he's coming, my lord.
You are representing all?
No, my lord. I am representing only 1 and 4, my lord.
So I am not asking about 1 to 4. I'm asking about 5A to 6.
5 to 6.
Affidavit in reply?
Complete.
Complete. At this stage, the also files the affidavit in reply. Let us start. You take note.
My lord, this provisional application is against an order of injunction passed by the trial court, which was against that I preferred a misappeal. In the miss appeal also, that order was affirmed. Now, your lordship, from the plain,
স্যার বলছিলাম এসে সিরিয়াস 30 স্যার অফিসে তো আমরা ওয়ারেন্ট পরে যে বেল নিতে আসে বলবো আমাদের অবজেকশন আছে না স্যার জাজে জিজ্ঞেস করে কি অবজেকশন
First, let us go through the order passed by the trial court. The order of injunction. Allowed?
Not-
Rejected?
Yes.
Allowed?
yes,
Why are you saying not allowed? Then you are not aware.
I am for the defendant
Please read it.
in the suit,
Allowed.
allowed.
Page
I'll come. By one order, your lordship, several applications were disposed.
several applications.
Yes,
My lord, only one indulgence. My lord, I was coming rushing from that building. My junior was there with regard to item number 1. Mr. Ganguly was appearing. And as I heard from my learned junior, my lord, he prayed for an adjournment and your lordship has been pleased to fix the matter on 17th.
17th Monday at 2 p.m.
Yes, I hope, my lord, that on that day after completion of his argument, he will, if he wants, he can file a written notes if he chooses. That is his
Let-
prerogative.
Let us reach
Yes.
17th.
Yes, because otherwise I am ready with the matter. Only I have to look into the judgment which has been placed by. Great.
your lordship will come to internal page 4 of the certified copy.
External, let us first,
Internal page 4.
first reach the external. Where is the order passed by the trial court?
Yes, kindly come to internal page of the certified copy. Annexed with your lordship's brief. Page 4. Your lordship has got the certified copy of the with your lordship's brief. It's a your lordship at the it's a last, not kindly come. Revisional application, your lordship.
Yes. At the end,
Page 4
There is
of
the-
that internal page
there is
4.
there is some
Order dated 18/4/2003.
permanent
22.
certificate of enlistment at the end.
There is a certified copy is there of the revisional application. Your lordship will kindly
1 minute.
of the impugned order.
Yes.
Page 4, your lordship, internal page 4.
Internal page 4. Yes.
Your lordship, last paragraph of that page. Your lordship, it starts
1
with
minute. 1 minute.
let the case record be taken up for passing order in respect of injunction application. Your lordship has got that?
First of all, an application under Order 6, Rule 17.
Several applications for
allowed.
police help, extension of interim order, all were taken up together
Together.
by
First of all was the amendment. Order 6 Rule 17.
Before that extension, there was police help order. That was rejected. Application for police help.
Yes, under section 151.
Yes. Now, I am aggrieved by this, Your Lordship, this injunction order.
So, internal page 4.
Yes, the last paragraph.
Hmm.
The brief facts of the plaintiff case is that the deceased husband of the plaintiff number 1, namely Devki Sharma, was inducted as tenant to the suit shop room by the father of the defendant number 3 in the year 1982 by dint of a tenancy agreement dated 22nd September 1982, and subsequently said Devki Sharma started to run a business in the name and style of Sharma Engineering and in the suit shop room. The deceased husband has also brought 2 lathe machines for the smooth running of the said business. After demise of the husband on 7/1/2010, Your Lordship will kindly note this.
You are the
I am the defendant number 3, the landlord.
landlord. Suit for declaration and injunction.
Injunction.
Acha.
Your Lordship will kindly note this date
7/1/2010.
because on this I will rely on 7/1/2010.
Hmm.
That it is admitted fact.
Hmm.
The plaintiff led the defendant to supervise the business of the predecessor, and the defendant undertook to pay some money to the widow, plaintiff number 1, and her minor children, plaintiffs 2 and 3. But gradually, the ill-motivated defendants, depriving the plaintiff and using the said machinery, started to run the business for their own benefit. The plaintiffs tried to close down the said business, as well as shop room by lock and key, firstly on 29/11/2019 and again on 13/3/2020. But the defendant restrained them vehemently. However, the plaintiff could not take any legal steps against them because of the prevalent lockdown caused by the pandemic outbreak of COVID-19. It is the apprehension of the plaintiff that the defendants may dispose of the said lead machine and disposes the plaintiff from the stockroom at any time. During the hearing, the learned advocate for the plaintiffs has referred and filed certain original documents attached to the frieze. They are the following: one unregistered tenancy agreement dated 22nd September 1982 in between Madan Lal Jununwala and Devki Sharma. 2 tax receipts being numbers also in the name of Sharma Engineering Work. 1 pro forma invoice dated 13/1/8/1999 in the name of Devki Sharma, issued by DB Machine Tools. 1 power of attorney along with the notarized certificate. The death certificate of Devki Sharma. 1 photo e-copy of electricity bill in the name of Dharmavati Sharma. The plaintiff, by filing the instant injunction application, has prayed for relief to the effect that the defendant should be restrained from dealing with or disposing of or alienating or transferring the tenancy right or creating any third-party interest in respect of the suit shop room, and restraining the defendants from carrying out further business in the name and style of Sharma and Engineering and Wires and using the machines of the plaintiff, and an order that the plaintiff be entitled to close down the said business. Kindly note this, the relief they have played.
Have you filed the injunction application?
Yes, it is on record.
The page number?
Your Lordship will kindly come to the
Page 29.
Yes.
29 onwards. Yes. Page 37.
Before that, Your Lordship will kindly see the plaint. Plaint is most important. What is the case of the plaintiff?
1 minute.
The plaintiff admits from the meaningful reading of the plaint, it appears that the plaintiff is not in possession of the property.
Where from you are stating so?
In the plaint itself.
Which portion of the plaint?
I'll come to that. The prayer and the kindly come to your lordship the affidavit in opposition filed by the plaintiff. I'm taking the amended plaint.
Yes, amended plaint. Amended plaint is page number,
It is your lordship in the
70.
affidavit in opposition.
affidavit in opposition.
Yes.
Supplementary affidavit in reply. Affidavit in opposition to the affidavit in opposition to that.
Your lordship has got that? The first annexure.
Yes.
Your lordship has
Yes.
the first page 2 of that. I'll read the entire plate. Everything depends on the plate. What is the case and what the court has granted.
So now you are referring to which?
The plaint itself.
Plaint itself. Yes.
Because what is the case of the plaintiff?
It is in.
In the affidavit in opposition, your lordship has got that?
Yes.
The first annexure.
Yes. Which paragraph?
Your lordship will come to page 3. What is the case? Paragraph 6.
Yes.
Page 3 of the plaint.
Yes, paragraph 6.
Your plaintiff states that on or about 2000. Your lordship note that. The said respondent number 1, Horil Sharma, alias Horil Sharma, who approached the father of the plaintiff number 224 and husband of plaintiff number 1 to do some supervisory work under him. Your plaintiff states that the respondent number 1 used to do the supervisory work under the husband of plaintiff number 1 and father of plaintiff number 224. At that juncture, plaintiff number 1 was the housewife and plaintiffs 224 were minors. The father of the plaintiffs 224 and husband had a trade license in the name of Sharma Engineering Work. The plaintiff states that the late husband of plaintiff number 1 and the father of plaintiff number 2 died on 7/1/2010. After the death of the husband of plaintiff number 1 and father of plaintiff number 224, the opposite party number 1 used to supervise our business. Thereafter, his son Om Prakash Sharma used to supervise the business of the plaintiff. The plaintiff states that thereafter 6-7 months, a meager quantity of money around 7,000 to 8,000 for supervising such business was paid to the plaintiff number 1. Thereafter, it was stopped completely by defendant number 1. Now, your lordship will kindly, what is the meaning of this? That Horil was in exclusive possession, running it. For few months, he paid some amount. Thereafter, nothing was paid to them. The plaintiff, the defendant number 1 was running the business unlawfully of the plaintiff, herein out of the firm of the plaintiff after 7/1/2010. The late machineries of the plaintiff. The plaintiff, being the owner of the said business, was deprived from being paid a single penny. The defendant number 1 continued to use late machineries and business whose owner are at present the plaintiff's hearing. The said business cannot be run illegally by the defendant number 1 and 2 continuously. The plaintiff, being the owner of Sharma Engineering was situated at Delhi Road, intends to close down the business. Your lordship, what is the purpose of the suit was to close down the business. The plaintiff states that the plaintiff 224 on or about 13th March 2020.
Wherein it is mentioned to close down the business?
Page 5,
Yes,
paragraph 11.
He intends to close down the
Close down
business.
it. That is the intention of the plaintiff. The plaintiff states that the plaintiff 224 on or about 13 March 2020, before the COVID lockdown, went to the premises and tried to put a padlock on the said shop room. The plaintiff states that when the plaintiffs tried to put a padlock at the said premises, immediately the defendants 1 and 2, in connivance and conspiracy with defendant number 3, tried to resist the plaintiff.
Who is defendant number 3?
3 is the landlord, myself.
Achha.
The said defendants further threatened the plaintiffs with dire consequences of life. The plaintiff states that on 29/11/2019, also the plaintiff tried to put a padlock on the said premises, thus closing down the said business. Yes. The plaintiffs declare that they are the owner of Sharma Engineering and advise under no circumstances that said defendants 1 and 2 forcibly and or illegally, unlawfully be permitted to run the business and earn profits from the business of the plaintiff. The law of the land does not permit the defendants to carry on unlawful business with the lead machineries of the plaintiff. Thus, at both the instances on 29/11/2019 and thereafter on 13 March 2020, when the plaintiffs went to take custody of the own machineries and shop room, Your Lordship, from this it is clear that they were not in possession. They went on that day to take possession and custody. The defendant numbers 1 and 2, in connivance and conspiracy with defendant number 3, tried to resist the plaintiffs 2 and 4, and they also used filthy language to the plaintiffs and threatened them with dire consequences of life. The plaintiff states that the defendants
Constructive possession.
Huh?
Constructive possession.
I'll come to that, Your Lordship, kindly, because I noted Your Lordship has noted the death of that person who is claiming to be the father,
Original tenant.
original tenant.
2000,
I accept what is written in the plate,
2001
2010.
or 2010.
10.
Achha.
He died, that is, Your Lordship will get it.
7/1/2010.
10.
Yes.
Your Lordship will kindly consider, after 5 years, 2015, they were all trespassers. Because under the new act, Your Lordship knows 2G. It's a commercial premises. Is a trespasser entitled to any
Suit of 21. Suit of 21.
21? 2015, even if I accept what is there in the plaint, except that the father of the plaintiff was a tenant. He died in 2010. 5 years, 2015, trespasser, not entitled to any relief.
Haril Sharma and Om Prakash
Sharma.
Sharma. These two persons are said to be
Sharma.
supervisors.
No, that is the plaint case. I'll come
What
to
is plaintiff?
that is the plaint case. I'm not disclosing my defense at the moment. It is what the plaintiff has stated. It is a plaint case what is there. But, Your Lordship, from the plaint it appears that after the death of the father, Horil Sharma is in exclusive possession of the shop room. And they went to close down the shop room, the plaintiffs, and they were threatened and driven away.
Is Haril Sharma and Om Prakash Sharma relative
Yes,
of the plaintiffs?
yes. Horil was
How
the
they are
brother of Devaki,
Haril is the brother of
the father of the plaintiff, younger brother.
Haril is the
Father of the, this is, plaintiffs number 2 and 4, 2 to 4.
2 to 4.
Their father, Devaki Sharma,
Devaki Sharma.
is elder brother of Horil.
Acha. Kaka.
Kaka.
So Haril is Kaka of this plaintiffs number 2.
2 to 4.
Acha. Uncle of 2 to
Yes.
4. And who is Dharmavati is the mother.
Wife of
Wife, mother and
of-
mother wife. Yes. And this Om Prakash,
is the son of
son of
Horil.
Haril Sharma. Yes.
Then Your Lordship will come to page 6 of the plaint. The plaintiff states that the defendants are also connected with some anti-social elements in the said locality, and until and unless the defendants are restrained from creating any hindrance or disturbance to the plaintiff for putting the padlock in the premises. The grievance is that they are not allowed to put the padlock on the shop. The plaintiffs will suffer irreparable loss and injury. That the defendant number 3 of the present suit, being the landlord, issued eviction notice through his lawyer Sadatat Kamal on 14/3/2000 to Sri Devki Sharma, predecessor of the plaintiff, in respect of the shop room, treating him as monthly tenant. And the said eviction notice, defendant number 3 stated that on or from 1/5/2000, the relationship of landlord and tenant between the defendant 3 and Devki Sharma shall absolutely cease and terminated, shall be incorporated.
Mr. Srivastava, what prevented you from filing a suit for eviction under section 2G?
I will file that. But what the plaintiff has done by the interim,
From 2015 to 2021, you have not filed.
no, because Horil was my tenant. I accepted Horil as my tenant.
Rent receipt was being issued in the name of
I issued the rent receipt in the name of Horil.
Horil
Yes,
or the sole proprietorship firm.
yes.
Which one? Sole proprietorship firm or Horil? In whose name?
Horil name.
Horil's name.
Yes.
So you had accepted.
Yes, I accepted Horil as a tenant. My case is that Devki, before his death in 2000,
2000.
he surrendered the tenancy, and then I inducted Horil as a tenant. And since 2000, Devki Sharma was not in possession.
This appeal was filed against temporary injunction
Yes.
or ad interim temporary injunction.
No, temporary final disposal.
Final disposal. So you had contested.
Yes.
So what document had you produced?
I produced Your Lordship, I produced the documents, Your Lordship, I'll say. The rent receipts,
In favor of
Horil.
Horil. In which page? Wherein we will get it? In the impugned order?
Yes, I'll come to that. Your Lordship, let me finish the plaint. What is the prayer relief they have sought and what the court has given them?
Relief in the plaint.
Yes,
After-
relief in the plaint. Because, Your Lordship, the injunction will be in support of the plaint,
Plaint.
not a separate
Not
order.
beyond that. Not beyond that.
Beyond that. The cause of action for the suit arose on 29/1/2019 and again on 13/3/2020 when the plaintiffs number 2 to 4, cause of action, Your Lordship, went to the suit premises and tried to close down the shop room under the name and style of Sharma Engineering and Wires, which is the shop room of which the plaintiff's deceased father, late Devki Sharma. Moreover, the laid machineries are of the plaintiff's father, and as such, the plaintiff is the owner of the said shop room. The defendants are forcefully carrying on business at the said shop room, and as such, the cause of action is receiving day to day. The plaintiffs further hereby declare that the plaintiffs are the 17 owners of the shop and establishment under the name and style of Sharma Engineering and Wires, along with laid machineries installed in the shop room.
17 is wrongly typed.
Yes, I think so. Now, Your Lordship will kindly see the prayer. Declaration that the plaintiffs are the owner of the said shop room, an establishment under the name and style of Sharma Engineering Wires situated at Delhi Road, along with the laid machineries installed in the said shop room. Permanent injunction be issued restraining the defendants 1, 2, and 3 from interfering in any manner whatsoever from putting padlock at the said shop room, being the shop and establishment under the name and style of Sharma Engineering Work. at Delhi Road, so and so. Receiver costed.
Hmm.
So the real was declaration
Hmm.
and injunction with regard to putting a padlock on the shop room. But what happened by dint of the interim order, temporary injunction, they have taken possession of that shop room. Because admittedly, Your Lordship, by the from meaningful reading of the plaint,
You had been made pro forma or principal defendant. Sanjay Kumar Junjunwala, defendant number 3, principal defendant, not pro forma.
no.
Hmm.
Your Lordship will kindly consider the prayer is in the plaint to put a padlock.
Hmm.
The court grants them an injunction by which they have taken possession of it. Let them put a padlock. I'm not against that. But how can somebody who is not in possession for more than 20 years can be put into possession by dint of the injunction order? That is my grievance. I am the landlord. I will select who will be my tenant.
So declaration as to
That they are the owners of that shop
plaintiffs are the
business.
owner of the shop room. And,
Yes.
And
to put a padlock.
restraining the defendant number 1, 2, and 3 from interfering in any manner whatsoever from putting padlock.
Padlock.
These two are the
Not for taking possession.
Hmm.
And by the injunction order, Your Lordship, the court has passed an interim order, injunction.
let us
Now kindly come to that order. Now Your Lordship will kindly take the injunction prayer or prayer in the injunction application also. It's similar to what is there in the
page
plaint. I'll come to that. Page 37 of the revisional application. Your Lordship has got that?
Yes.
Kindly come to page 37.
Hmm.
An order of injunction be passed to restraining the respondents, particularly the respondent number 1 to 3, from dealing with or disposing of and or alienating and or encumbering, transferring the tenancy right and or creating any third party interest in respect of the said shop room. And B, an order restraining the respondent not to carry out further business in the name and style of Sharma and use the machineries, and or the petitioner be directed to close down the business. Your Lordship has seen what is the, nowhere they have prayed injunction from evicting them or taking possession or whatever it is. And what the court has done? By dint of that interim order, they have forcibly entered into the premises. Now Your Lordship will kindly come to the page for the immediately.
Place the order passed in the title suit.
Yes. Now Your Lordship will kindly come to the certified copy. I was placing the order. What is the injunction that the court has given?
It is order number 35, not 33 or 38.
35.
That is the correct one.
35 dated
18/4/2023.
Yes.
Yes.
Kindly come to page 7, ordering portion.
Application 151 police. Why, first of all, police help, the first,
After the ad interim order they got,
hmm,
and they prayed for police help to,
to put the padlock.
no, to get into possession. That is the thing. Prayer is something else.
Mr. Srivastava, 151 application.
Yes,
Have you furnished the copy of the 151 application?
I don't. What is there, Your Lordship? Kindly.
That is required.
I don't
What has
think
been
so.
stated in the 151 application?
I don't have that. It is with them.
Cannot be. You have contested.
Yes,
Hmm.
but I'm not having that. Or Your Lordship have to give me some time to get it.
Let us continue. But that is required. The application under section 151 CPC. Seeking
Just a
police help.
minute, Your Lordship. Your Lordship will kindly come to the certified copy.
Hmm.
The order is there, improved
Yes,
order.
order is there.
The
You are referring to,
150. Page, Your Lordship, page 1 of the certified copy.
okay, you are referring to 151, the order passed in
Yes, yes.
under 151.
There is fixed for hearing of the application under section 151 CPC for police help. The application under 151, the application under order 6, so and so. The plaintiff have filed one petition praying for extension of interim order. Now, Your Lordship, the next paragraph. Let the application under 151 fixed filed by the plaintiff praying for necessary direction upon the OC for implementation of the ad interim order of this court be taken up for hearing at first. Heard, perused, considered. Let the case be taken for passing order of the on the instant application. The plaintiff, by filing the instant application, has prayed for necessary direction upon the OC Dankuni for implementation of the ad interim injunction order of this court on the ground that the defendant, in spite of the ad interim injunction order of this court, are trying to dispossess the plaintiff from the suit premises, and for such illegal act of the defendant, the plaintiff have lost his. Your Lordship, in the plaintiff states is not.
Let us continue.
The
Trying to
plaintiff has lost one.
trying to dispossess the plaintiff.
It changes in 151.
Let us move further.
Hmm.
Trying to dispose the plaintiff from the suit shop room, and for such
For
illegal
such
act-
illegal act of the defendant, the plaintiff has lost GD.
no,
the-
why? Yes, why he is seeking police help?
The defendants, on the other hand, by denying all the allegations of the plaintiff, have alleged that the plaintiff number 1, namely Dharmavati Sharma, is not the legally wedded wife of Devki, and no such incident as alleged by the plaintiff has ever taken place on 21/3/2023. Considering the application submission of all sides and entire case record, this court is of the view that any direction upon the administration to do or undo anything without any active application of evidence regarding the alleged wrong by the defendant should only burden the administration. Besides, the ad interim injunction order has been granted by this court only on the satisfaction of prima facie case and the balance of convenience, and the entire material has not come under the scrutiny of court. Hence, this court finds no proper to invoke its inherent power to grant police help.
Achha.
Now, Your Lordship,
Not allowed.
so Your Lordship will kindly consider that after the interim order, ad interim order, they took possession of the premises. Because at the time of filing of the plaint and moving of the injunction application, they admitted cases that they are not in possession and they wanted to lock the shop. But after ad interim order, they took possession.
From nowhere, it is evident that they were not in possession.
They admittedly
Wherein?
Admittedly in the plaint, Your Lordship will kindly read the plaint. What is their prayer and what is they are saying after the death of the father. Horil took possession. He was first supervising and paying them some meager amount. After that, he stopped.
Defendant number 1 and 2, 1 was acting as supervisor.
That is their case. But I'm on possession, Your Lordship.
Yes. So they are trying to establish constructive possession.
Yes,
Yes.
but actual they are not in possession.
According to you,
Yes,
it is not admitted that they are not in possession.
because their prayer is to put a padlock,
But
not to get into possession.
that you are interpreting.
No, that is the prayer, Your Lordship, in the plaint and the injunction. Where nowhere they have said it that they are in possession and they want to establish their possession right in the property.
Sure.
Because their prayer is, Your Lordship, that they want to close down the shop, put a padlock, and their machinery should not be alienated or third party interested. This is what the prayer is.
Prayer is.
Then admittedly they cannot be put into possession.
Let us proceed to the injunction order. Order
Yes.
of injunction passed by the trial court.
সেটা আমি বলবো আগে কেসটা কি প্লেন্টিভে সেটা বলো
Through the amendment application, what they had sought for
Yes. এক মিনিট হ্যাঁ amended plate after paragraph 15.
Mr. Srivastava.
Your Lordship will kindly come to the amended plaint. What amended in the reply 15A. That is the amendment they have sought.
Yes, that the division of three of the present suit being the landlord should have a lawyer on
This amendment they sought.
which to be shown that this is a plaintiff's
Not Your Lordship recovery of possession or
criticism of all plaintiffs in respect of the shop rent, treating him as monthly premises tenant. Eviction notice.
they wanted to introduce an eviction notice
Dated 12th March 2000.
2000.
Much
That
prior
is-
to much prior to the death of Devaki Sharma.
No,
Yes, Devaki Sharma expired in 2010.
10. This is 2000.
2000, much prior to the death of
Yes.
Devaki Sharma.
Yes.
To show that Devaki Sharma was the tenant. But is the
They wanted at
Yes.
that point of time he was a
Established.
tenant.
At that point of time he was.
He was at after that it happened. So Your Lordship, by amendment also they did not claim any possession.
This amendment won't help us.
Yes,
Then
it's redundant for the present moment. Your Lordship has seen
thereafter,
what happened.
let us proceed to the order of injunction.
Interim order that they put up. Interim order. Interim order of the- interim order of the property.
Mr. Srivastava, place your portion. Defendant number 3 denying all allegations. Page 5 of the internal page 5 of the order passed by the trial court. Last paragraph. Internal page
Defendant
5.
number 3 denying all allegations raised by the plaintiff has contended in his written objection that the plaintiff had procured an ad interim injunction order by misleading the court, whereas the predecessor of the plaintiff have already surrendered his tenancy in favor of defendant number 1 in the year 1999. During hearing, the learned advocate for the defendant number 3 has argued that the landlord shall not transfer the tenancy. Then why is he to be restrained from entering into his own property? He has submitted that it is not possible to seek for closing down the business in the form of temporary injunction. He has lastly argued that the plaintiffs are not in possession over the suit property. Then the question of their dispossession does not at all come into play. This was my specific case. Now, HON'BLE and what?
You have stated that plaintiffs have already surrendered their tenancy.
That is my case.
Submission.
Yes.
In support,
I've my tenancy agreement, Your Lordship, one document I submitted.
you had submitted.
Yes,
Acha.
the authenticity is to be true.
Is it mentioned?
Then
in
Your
the-
Lordship will kindly come.
Is
What
it
is the-
mentioned in the order? Is it mentioned in the order?
No.
Acha.
Now Your Lordship will kindly take the next paragraph. What is the defense of the defendant number 1 and 2? The learned advocate for the defendant number 2 has agitated that the injunction application was not disposed of on merit, and the plaintiffs have obtained the ad interim injunction order in the suit by misleading the court. He has argued that the landlord is the best person to decide who is his tenant.
So earlier there was a suit. 479 of 2019.
No, this suit itself.
This
There
suit
are
of-
two suits.
My lord, earlier,
You will get the opportunity.
There were two suits.
No, we are in the list being title suit number 70 of 2021.
Yes, there were two suits. One suit was by the plaintiffs here before Your Lordship.
This one
The other was by HON'BLE against the plaintiffs.
seeking declaration.
Yes. That suit is this.
Is that also pending?
Yes.
What is the status of that suit on?
I think they are appearing before Your Lordship.
You are not made a party therein? Obviously,
Yes,
you got
I
a
think
party.
so.
At least you will be a pro forma. At least
Yes,
you will be a pro
I have
forma.
not seen that papers. That
Okay.
is my difficulty, Your Lordship, because that was not handed over to me. This case has been handed over. That is the difficulty, Your Lordship. Clear picture, I cannot say. What is the position with regard to that?
Acha. Let us proceed.
Now, Your Lordship, the learned advocate for the defendant to have agitated that the injunction application in this was not disposed of on merit, and the plaintiffs have obtained the ad interim injunction order in this suit by misleading the court. He has argued that the landlord is the best person to decide who is his tenant, and in the present suit, defendant number 3 himself denied the tenancy of the plaintiff. Then how they are entitled to any temporary injunction, especially when they are not in possession of the suit property? This is the
That is the contention of defendant number 1 and 2. 1 and 2.
by drawing the attention of this court towards the document filed by the plaintiff, he has further denied that those are documents of afterthought. Your Lordship, this is the case of the defendant 1 and 2 before the court, trial court. They have now changed. They have clubbed together here. They have now against me, against the landlord.
After the passing of the order after the passing of the impugned order, or
After I approached this High Court.
that is the passing of the impugned order.
Yes.
Acha.
Now your lordship will kindly see what is the your lordship, because at the time of final disposal of the injunction application, he has made the rule absolute, which was ad interim. That. So your lordship,
Till the disposal of the suit.
till the disposal. So that what was the term of that ad interim order, your lordship has to look into.
No, place this one first. Place this one.
Yes.
The entire impugned
Your lordship
order
will
passed to the
tell-
trial court first.
Yes. Then in reply, the learned advocate of the plaintiffs have argued, that is page 6, your lordship,
Yes.
has argued that the documents so produced by the plaintiffs and the defendants are as well are required to be proved at the time of the trial. At this primitive stage, this court, while adjudging the temporary injunction application, is to see whether the essential ingredients to allow the application are met up or not. Besides, the facts stated by the adversaries are beyond pleading. An electricity connection over the suit property is still in the name of the plaintiff number 1, and the eviction notice was never acted upon by them. Heard, perused, considered. On consideration of the entire application, written objection, plain written statement, submission of both sides, and the entire case record, this court is of the view that none of the parties shall be prejudiced if the ad interim injunction order so passed by this court be made absolute till disposal of the suit, in order to prevent any further future breach of peace over the suit property. This is because the allegation and counter allegation raised by each set of contesting litigants require exhaustive trial, and this court at this primitive stage does not find it feasible to make any remark over the same. This will lead to prejudging the suit only. Besides, the plaintiffs show their primary case to face the trial, and the balance of convenience and inconvenience also till on them. Hence, order that the ad interim order relief is made absolute from the suit. Your lordship, what is that? Granted to the plaintiff to the tune that the defendants are hereby directed not to dispossess the plaintiff. Your lordship, that prayer was not there in the plaint and injunction application. By this portion, your lordship, the plaintiff has taken possession. Because the prayer was something else. The pleading is something else. Just mechanically he passes an order. Your lordship, in usual all cases that is.
So you are aggrieved by this portion of the
This
order.
portion directed not to
dispossess the plaintiff.
dispossess the plaintiff from the suit shop room or change nature character. I am not aggrieved. But
You are
how he got this? There is no pleading to that respect. And taking advantage of this, he has entered into possession of my suit. Because, your lordship, the court has to see what is the pleading of the parties. Where from he got that plaintiff is being dispossessed?
yes.
This is what the court has done. This is one aspect of my submission, that the pleadings,
Beyond the pleading.
beyond the pleadings and the relief claim,
Yes.
and the second limb is, your lordship, 2G. Even if I accept that Devki Sarma was the tenant.
Can we discuss here in section 2G?
Yes, because, your lordship, the plaintiff has to.
Have you prayed? Have you prayed for
It's your lordship, a legal position, your lordship, at any point of time I can raise. There cannot be waiver to that.
Any point of time you can raise.
Yes,
Yes, that right you have.
yes.
But have you raised till now?
Yes, in this we have raised.
True? In the written statement, wherein you have mentioned that? Raise the written statement page. Written statement has not been filed. Do you have a copy of the written statement? Do you have a copy of the written statement?
Yeah, it is there,
page?
lordship brief.
Where-
Their affidavit in opposition, your lordship,
All in affidavit in opposition.
because it is there, your lordship. I'm referring because all the documents have been provided in one place.
Not by you. Yes, written
Page
statement.
29.
Page 29 you are referring, yes. Which paragraph?
It's not there.
পাখাটা বন্ধ করে দেবেন পাখাটা বন্ধ করে দেবেন It is not there.
No.
So 2G cannot be raised.
It's a point of law, your lordship, at any, your lordship will consider what is my submission.
Mr. Srivastav, you are well aware. You have filed the written statement.
Yes.
In the written statement,
It's not, I've not taken.
you have not taken that.
But your lordship, what I'm submitting, kindly hear me.
You had the right.
Kindly hear me for a moment, your lordship. The plaintiff has to prove his case.
Yes.
The plaintiff has to prove his right
Hmm.
before claiming any. If he has no right,
Hmm.
I don't file any written statement.
Yes.
I don't file any written statement. At the time of argument, I can place on what is material on record, the plaint.
Hmm.
If from the plaint it appears that the plaintiff has no right in the property, can he claim any injunction or any order? I don't file my written statement. Your lordship will
Mr.
kindly
Srivastava.
consider.
Can you go beyond the pleadings? Can you go beyond the pleadings?
Your lordship, the plaintiff has to first prove
That
his case.
That is separate issue. That is separate issue.
Yes.
It is well settled. Plaintiff has to prove his case.
Then only
Otherwise,
my
otherwise he will fail.
yes. If I can show from the plaint
Hmm.
that a plaintiff has no right, he is a trespasser from the plaint itself. I don't have to put in a pleading for that. Your lordship, from what has been stated in the plaint,
Hmm.
it appears that the plaintiff has become a trespasser in the suit premise. I accept all the allegations that is made in the plaint. I don't file my written statement. I don't lead my evidence.
Hmm.
Just because There is no written statement, no written objection, or no evidence from the defendant. The plaintiff's suit cannot be decreed. The plaintiff has to prove his case.
Yes.
Your Lordship, there is completely blank on my side.
Hmm.
But it is for the plaintiff to prove his case. And Your Lordship, by operation of law,
Hmm.
if the plaintiff becomes a trespasser,
Hmm.
is he entitled to any declaration of right?
That is another aspect.
That aspect I'm
that you can-
submitting.
That you can raise.
I'm raising that. That's my submission.
Not 2G can be taken into consideration.
No. Because of 2G, he has become a trespasser. That is by
Consequences.
operation of law.
By operation of law, yes. Yes. Anything?
Because in the plaint itself, he has stated that Devaki died in 2010.
5 years.
5
from
years, 2015. It is a commercial property. So the widow has no right to remain till he is alive. She is alive. Commercial property, Your Lordship. It's not residential. Only for residential, the widow has a right till her death. But this is a commercial property. 2G specifies that they become a trespasser. The court has to consider that.
दिन पे बोल
2G.
Page 1 page Chennai Act.
2G. Your Lordship will take it. May I place it?
Yes, yes.
Tenant means any person by whom or on whose account or behalf the rent of any premises is or but for a special contract would be payable and includes any person continuing in possession after termination of his tenancy. And in the event of death of any tenant, also includes for a period not exceeding 5 years from the date of such tenant or from the date of coming to force of this act, whichever is later. His spouse, son, daughter, parents, widow of his predeceased son, who are originally living with the tenant up to the date of death of the tenant as members of his family and were dependent on him, and who do not own or occupy any residential premises. This is for residential.
First portion is residential.
Residential. And in respect of premises let out for non-residential purpose, his spouse, son, daughter, parents who were ordinarily living with the tenant up to the death of his death as members of his family and were dependent of him, or a person authorized by the tenant who is in possession of such premises, but shall not include any person against whom a degree order, provided that at the time limit of 5 years shall not apply to the spouse of the tenant who ordinarily living with the tenant up to his death as member of the family and dependent of him and does not occupy any residential premises. So the spouse, Your Lordship, the widow or the spouse husband gets the benefit till her death only in respect of residential premises.
Provided further.
They have a preference over if I let out the premises again, then they will be given preference.
Mr. Srivastava, next portion, provided further,
Further, the son, daughter, parents, or widow of the predeceased son of the tenant who are ordinarily residing with the tenant in the said premise up to the death of the tenant as member of his family and was dependent on him, who does not own or occupy any residential premise, shall have a right of preference for tenancy. If I again let it out, then they should be given preference.
in a fresh agreement in respect of such premises on condition of payment of fair rent.
That is there. If I let it out,
This, thereafter, this proviso,
is your lordship is applicable to non-residential also.
proviso shall
If I
apply.
let it out, if I further let out the premises, then this should be given preference. But this doesn't mean that after 5 years they are still a tenant. They will have no right. They are ranked trespassers.
Learned Counsel, is this the proper, should not, it is not at all expected from a senior counsel. Kindly be seated. So this one is not applicable in respect of commercial, non-residential.
Non-residential, they cannot claim that the widow is alive, so they can remain in the place. That do not apply. So after 15, they are trespassers. The court has to look into that. The court has to consider all the legal position and the right. What the plaintiffs are trespassers admittedly on the basis of the plaint itself. If they are trespassers, how can any order of injunction could be passed in their favor?
So you are banking upon two issues.
Two issues.
First is not to dispossess the plaintiff.
Because the court has made out a new case.
According to you, the plaintiffs were not in
Pleadings are something else. Court is passing an order something else.
Plaintiffs were not in possession, according to you.
Yes. And their
And the-
relief claim is something else. The court is granting them some other relief.
And the second, point is, as a consequence of section 2G,
On the
that they have
basis of the averments made in the plaint itself.
plaintiff itself,
I could have, Your Lordship, I could have brought up application under Article 7 Rule 11 for dismissal of the suit on the basis of the plaint. But that does not deprive me for taking objection to the passing of injunction order. Just because I have not brought that application.
let us go through the impugned order now.
Yes.
Everything has been placed, barring the impugned order.
No. Your Lordship has to go through the ad interim order first, because that was made absolute.
Ad interim order, page. Ad interim order will bear only the version of the plaintiffs.
Your Lordship will kindly come to page 17.
17 of
79
Opposition.
is the opposition.
79.
Yes.
Yes.
When in the order, impugned order itself, the court records the date of death of the plaintiff, predecessor of the plaintiff. And then he proceeds. Your Lordship has got that?
Yes, yes.
That is the ad interim order. The free facts of the plaintiff case is that the deceased husband of the plaintiff number 1, namely Devki Sharma, was inducted as tenant to the suit shop room by the father of the defendant number 3. in the year 1982 by dint of a tenancy agreement dated 22/9/1982. And subsequently, the said Devaki Sharma started to run a business in the name and style of Sharma Engineering and Wires in the suit shop. The deceased husband has also brought 2 late machines for smooth running of the said business. After demise of her husband on 7/1/2010, he records the death. The plaintiffs led the defendant to supervise the business of his predecessor, and the defendants undertook to pay some money to the widow, plaintiff number 1, and her minor children. But gradually, the ill-motivated defendant, depriving the plaintiff and using the said machinery, started to run the business for his own benefit. The plaintiffs tried to close down the said business as well as shop room by lock and key, firstly on 29/11/2019 and again on 13/3/2020. But the defendant restrained them vehemently. However, the plaintiff could not take any legal steps against them because of the prevalent lockdown. It is apprehension of the plaintiffs that the defendant may dispose of the late machines and dispose the plaintiff from the shop room at any time. During the hearing, learned advocate for the plaintiffs has referred to certain documents. Then you will. The plaintiffs, by filing the instant injunction application, has prayed for relief to the effect that the defendant shall be restrained from dealing with or disposing of or alienating, transferring the
Mr.
tenancy right.
Srivastava, what is the power of attorney along with power of attorney? Annexure 5 document.
I do not. It is for the plaintiffs are given that.
Plaintiffs had given.
Just a minute. Your Lordship, I'll
Authorizing defendant number 1 and 2 or defendant number 1.
just a minute. Your Lordship, I think it is. Yes, Your Lordship. No, it's not there. You have power of attorney?
They will place. They will place.
Yes.
It is just 52 minutes past 11.
Your Lordship will take page
The entire
79 at
day is
bottom.
left.
Page 79 at the bottom.
Page, yes, page 79 at the bottom.
The plaintiff, by filing the instant injunction application, has prayed for relief to the effect that the defendant should be restrained from dealing with or disposing of or alienating or transferring the tenancy right and creating any third party interest in respect of the suit shop room and restraining the defendant from carrying out further business in the name and style of Sharma Engineering Wires and using the machinery of the plaintiff, and an order that the plaintiff be entitled to close down the business. This was the prayer. Your Lordship will kindly see. On careful perusal of the aforesaid document filed by the plaintiff, it transpires that the deceased predecessor of the plaintiffs have legal right and interest over the suit property, and in continuation of the present plaintiffs are also clothed with the said legal right and interest. As such, this court, Your Lordship, I am joining issue here. On careful perusal of the aforesaid document filed by the plaintiff, it transpires that the deceased predecessor of the plaintiffs had legal right and interest over the suit property.
Hmm.
And in continuation, the present plaintiffs are also clothed with such legal right and interest. I am joining issue because 2G has already come into operation.
That you can raise.
So the present plaintiff do not have that right and interest, even if there is any. Because after 2015, they have no right in the shop room.
Mr. Srivastava, is it automatic?
Yes,
After the recent judgment passed by the Honorable Apex Court,
Apex Court held.
has
No, what
are the this legal layers of the plaintiffs not entered into the stepped into the shoes of the
no,
deceased plaintiff?
Your Lordship, the Supreme Court has held
Hmm.
that where this act came into effect, Your Lordship, when 2001.
2001.
The Supreme Court held that where the tenant has died before coming into effect of this act,
Hmm.
this 2G will not apply. Because
He has expired
after the coming in,
2010.
that is the difference,
No,
Your
no.
Lordship. Because
Yes.
Your Lordship,
Let us continue. Okay.
before
Correct.
1956 Act was there, Your Lordship, so it was heritable.
I thought that he has expired prior to the coming
Coming
into
into
effect of
effect, it's
1990.
not that.
After that.
So it has an automatic operation. You don't. There is no declaration required
yes.
as regard to the trespasser. As such, this prima facie case is of the court is prima facie of the view that the plaintiff should not be dispossessed from the showroom without due course of law. Where did he get that? Where is that prayer for the plaintiff that he will not be dispossessed when the plaintiff has made some other prayer? Earlier, he states that these are.
That is your contention that relief claimed is something else and the
Pleading is also something else.
and what has been provided, that is something else.
Something. The court has, without applying the mind, what is the real relief claimed by the plaintiff? However, keeping the social justice and public policy in mind, this court does not find any justification to close down the running business of the Sharma, which may be bread earner of several workers, especially when the matter of exhaustive trial is necessitated and involved to adjudicate whether the defendants by illegally using the lead machines are illegally running the aforesaid business or not. And then the plaintiff has at present any rightful claim over the said business or not. Hence, it is ordered that the interim leave as paid for by the plaintiff is hereby granted. I join issue. This is not the prayer that the plaintiff claimed. With part modification that the defendant are hereby directed not to dispossess the plaintiff.
Achha.
I am aggrieved by that, Your Lordship.
What has been discussed by the first appellate in the
First
Mississippi?
appellate court
the
just
Mississippi?
said that the suit is pending, hence it Kindly come to Your Lordship. First page of the certified copy.
Yes.
Order dated 14/11/2020.
14/11/2024.
Today is fixed for order regarding stay. Appellant and respondents have filed Hajira before this court. The record is now taken up for passing order. Learned advocate for the appellant had, during the hearing of the said of his stay petition, submitted that the impugned order of injunction granted by the learned trial court to the respondent is not proper, as the respondent number 1 to 4 are not in possession of the shop room. and the defendants 1 and 2, pro forma defendants 5 and 6 of this appeal are in fact in possession at that time. He further submitted that the instant appeal has been admitted and there are good grounds for him to succeed in his appeal. But unless the impugned injunction order was stayed, his success in appeal would become infructuous, as the respondents would be able to gain possession of the stockroom.
Have you filed the miscellaneous appeal? Copy of the miscellaneous appeal?
Four zero, Your Lordship.
40 of the affidavit in opposition.
No,
Hearing.
revisional application.
Dharmabuddhi Sharma, Bharat Bhushan sons, son of yes, son and son, 5 and 6, yes. Acha. Yes, let us now continue.
I was placing the order, Your Lordship. The third paragraph. Learned advocate for the respondents 1 to 4 on the other hand submitted that the submission of the learned advocate for the appellant was wrong, as the respondents are already in possession of the software, and that there was some misunderstanding between the respondent numbers 1 to 4 and the pro forma respondent, which has been amicably sorted out between themselves, due to which the pro forma respondents are no longer trying to forcibly occupy the shop room, unlike the appellants who are trying to do so, for which the appellants have been granted injunction in this matter against the appellant. He submitted that the injunction order was tenable considering the facts of the matter and hence need not be stayed. Heard both sides, peruse the materials on record. It appears from the submission of both sides and materials in the present record that the respondent number 1 to 4, being the plaintiff in the trial court, are presently in possession of the suit scheduled shop room, and that they have been granted ad interim injunction in this matter by the learned trial court against the appellant. Another defendant, which was subsequently confirmed and made absolute after hearing both the sides. The injunction order has spelled that the appellant would not dispossess the respondent from the shop room and shall not change the nature and character of the suit property and would not alienate or transfer the relayed machines in the said room till the disposal of the present suit. Such be the present state of affairs, there is apparently no prima facie case for stay upon the impugned order. In fact, stay of impugned order would result in dispossession of the present occupants from the suit property and creation of third-party rights upon the same, which end in multiplicity of proceedings. Hence, this court is not inclined to come.
So in the during misappeal hearing also, you had not produced the surrender. What you have stated, that the plaintiffs had surrendered. Plaintiffs had surrendered.
Yes. Your Lordship.
Have you placed the
We produced that.
agreement
That
for
was our
surrender?
case. That was our case.
Wherein it is mentioned that
Yes.
they produced? No, in the impugned order, wherein it is mentioned.
It's not mentioned. It's mechanically passed. No application of mind is there. That is my grievance. Proper application of mind and the plain pleadings are to be considered. Both the trial court and the first appellate court did not apply.
In the misappeal, wherein have you mentioned?
Misappeal stay petition daughter. Your Lordship will kindly come to page 49 of the revisional
Yes,
act.
49.
Paragraph 6 onward.
Yes.
Your Lordship will kindly. At paragraph 7 specifically it's stated that surrendered and then
Where is the annexure? Herein? Mr. Srivastava, the annexures,
yes, yes.
not annexed to the petition.
No, no. Your Lordship will kindly see supplementary affidavit to the revisional application. Your Lordship has got the first one.
Yes, there is annexure.
Page 12. No, page 5, 6.
Yes,
Page six.
6. Yes, that is
Page 6.
annexure D.
Yes.
And a copy in page 50, first paragraph, last line. A copy of the said family settlement is annexed here too and marked with the letter A.
That is page
5.
6. But it starts notarized.
Yes, starts from page 5.
Next page.
Why it is mentioned annexure D? And
Because
annexure-
Your Lordship, I'm
annexure
continuing
D.
from my revisional application. It's a part of the revisional application, Your Lordship.
So this one is the agreement, family agreement.
They have challenged that. That is for the trial court to decide. On evidence.
But that was placed before
Yes.
the during the misappeal hearing. Anything more?
Just a minute. Your Lordship may kindly come to my supplementary evidence, page 18.
Yes, page 18.
This is an application was made on behalf of defendant number 1 and 2. Your Lordship will kindly see. The plaintiff's predecessor, Devki Sharma, surrendered his possession amicably by written agreement in favor of full-blooded brother Horil Sharma in the year 1999. The said Horil Sharma has been running the business in the suit property for last 24 years. With his son only, his name in the municipality and giving trade license to the local municipality. It is mentioned that the Dharmavati Sharma was a concubine of Devaki Sharma and other plaintiffs are illegitimate children, and the legally married wife Radha Devi still alive and resides in Bihar. That the plaintiffs are daredevil and greedy persons. They are contemplating and devise the plan to grab the suit property by hook or by crook. The plaintiffs have taken a dirty plea so that they can drag the case for an indefinite period. The plaintiffs are not willing to complete the trial of the case. Rather, they are exerting pressure and creating a pandemonium and tried to take possession of the suit room illegally with furious wrote on 21/3/2023. The innocent defendant's son, Om Prakash Sharma, under compulsion with his landlord lodged diary being so and so before Dankuni PS, apprehending his life and property being endangered. So the instance suit required to be heard immediately, otherwise the defendant would not be safe to
Yes,
be in the premises.
gone through.
Now your lordship will kindly see this is what the defendant numbers are taking the stand before the trial court. They are now changing here in this court is something else. Your lordship, with regard to 2G, I'll place some judgments that it is automatically they become no declaration is required from the court. By operation of law, they become trespassers. Those judgments are there, your lordship. I'll place that.
When?
I don't have it here now. I'll place it, your lordship, by tomorrow.
My lord, kindly be fixed on Wednesday, my lord, 12:30. My
Start.
my lord,
Start. No,
council is
start.
there.
No.
Then my lord,
No,
kindly
no.
pass over, my lord, at least at 2 p.m. My lord, fix kindly.
No. You start.
Give me the opportunity, my lord.
You start.
My
You
lord,
start.
my lord,
Council.
we have
Somebody should start. One has to start. You start.
Your lordship will tell me.
My lord, kindly be, my lord, one apology, my lord. Then only one day, my lord.
You start.
We have never taken any time or adjournment, my lord, any day, my lord. Every time we are prepared, my lord. The arguing council is court number 37, my lord, ongoing, my lord.
You can start. In the meantime, let the arguing council come.
Then kindly be
Here
fixed at 2 p.m., my lord. We will come, my lord.
Learned council, once it is stated from this end, that's final. You will have to commence.
My lord, once we have indicated my learned senior,
You are the advocate on record?
I am the advocate on record, my lord.
Yes.
Once my lord, I am indicating by the learned senior friend has stated by my lord, the Horil Sharma and the Devaki Sharma. Differences, my lord. Devaki Sharma is the elder brother, and the Horil Sharma is the younger brother, my lord. Kindly be noted, my lord.
Till this present moment, this court is aware of the fact that the original tenant was the elder brother.
Elder brother Horil Sharma.
That is Devaki Sharma.
No, my lord, elder brother is the Devki
Acha,
Sharma.
whoever,
The youngest
whoever,
brother is the
whoever
Haril
may be,
Sharma, my lord.
whoever may be the elder or younger, Devki Sharma was the original owner.
Original.
He was running a business under the name and style, Sharma,
Sharma and Voyages.
and the said Devki Sharma expired during the year 2010,
10, my lord.
leaving behind his wife, Dharmavati, and three sons.
3 sons, my lord.
Okay. Thereafter comes Haril Sharma, younger or elder brother of Devki Sharma. According, you are representing
Respondent number 1 to 4, my lord.
1 to 4. That is the legal heirs of
Legal heirs
Devki,
of the and the wife
Dev-
of the Devki Sharma.
legal heirs of
Devki Sharma, my lord.
Sharma. So you had granted.
Interim order.
Hmm?
I have granted an interim order.
No. You had allowed Haril Sharma to look after the business. According to you,
My lord.
Haril Sharma to look after the business. What about Om Prakash Sharma, the son of Haril Sharma? Both were, acha, both were granted to look after, to supervise the
He's the
business.
supervisor. My lord, the Haril Sharma, he's come in. My brother is there, my lord. He will come my office. He said that no business is there, so I am taking that you have to take in my business and supervision. Let them. His son has come and joined the business, my lord. Same thing, my lord, supervision business.
And thereafter, according to the plaintiffs, you had been paying them rupees 7 to
8,000 per month, my
per
lord.
month. And thereafter, I think you had stopped paying and the real trouble started.
My lord.
In the meantime, Haril Sharma has also expired.
Haril Sharma is already expired in
Has
the
expired, leaving behind Kishori Devi,
Yes.
his wife,
Substituted.
Kishori Devi.
he's died on 2024, my lord.
He has been substituted. He has been
Substituted,
substituted by Kishori Devi.
Kishori
No,
Devi,
son was already on record.
son was already in
Acha,
party, my lord.
Om Prakash was already on record. So now it is Dharmavati Sharma and her 3 sons and Kishori Devi and 1 son on the one side, and the landlord is on the other side. Yes. Now, what you have to submit?
Firstly, I have indicated before the lordship title suit number 479 2019, my lord.
2019, prior to this one.
Prior to this suit, the Haril Sharma and the Om Prakash Sharma has a file a suit for declaration and permanent injunction restraining the defendant. Defendant is Sanjay Jhunjhunwala. I am the
Learned
1 to 4.
Learned counsel. Has that document been placed
I think
during the hearing of the injunction application? Because we cannot go beyond the documents placed during the hearing of the injunction application. We'll have to be within that ambit, not beyond those documents which had been taken into consideration by the trial court and during the misappeal hearing. Are you ready?
my lord, kindly give me the 1 day, my lord. 1 day accommodation, my lord. I will come, I will do my hearing, my lord. By tomorrow, my lord. I will do, my lord. By tomorrow.
Tomorrow there won't be any
No adjournment, my lord.
adjournment.
No, my lord.
Take it on Wednesday. Tomorrow I'm not coming.
Then, my lord, Wednesday, my lord, 12:30, my lord.
Only the citations authorities are to be
Kindly
placed.
take it up on Wednesday.
My 12:30, my lord, kindly.
No, morning,
My
10:30.
lord, 12:30.
No.
Please, my lord.
No. At 10:30. Nin. Henceforth adjournments won't be granted, learned counsel.
No, my lord. I'm
Hence-
prepared and come back, my lord.
The learned senior counsel representing the revisionist petitioner commences his submission and submits exhaustively. Full stop. After elaborate submission, after completion of his submission, the learned counsel seeks an accommodation to file authorities in this regard. Full stop. Paragraph on consent of both the sides, let the matter appear on Wednesday. Wednesday বলার দরকার নেই. Appear on 12th of August at the top.
My lord, kindly fix at 12:30, my lord.
Being part heard. Being part heard. At the top,
Yes, sir,
being
yes.
part heard.
আমাদের লিখে দেবে আমাদের কপি।
Mr. Srivastava, you will have to produce the
Yes, yes.
citations and the application under section 151 CPC. Application under section 151 CPC.
Yes, my lord.
Learned counsel, application, copy of the application under section 151 CPC.
For police help.
Whatever that they know better than the court.
বইটা দিন,
And-
বই।
Which book?
Premises tent, yeah.
This one?
No, not that one. কোথায় গেল?
Do you have it? Do you have the book?
Wait, squad item.
But
I'll find out.
that is not been herein.
No, your lordship was looking at. Yeah.
And the power of attorney. Yes. And the power of attorney. You will be arguing.
They are arguing on
বুধবারে
sir.
Since when the
বুধবারে।
plaintiff has not concluded, the judgments has to be cited, but otherwise we will not get an opportunity to review.
Yes, you will get the opportunity on Wednesday.
Wednesday.
If the citations will be given tomorrow, so that we can conclude the argument.
Yes. Tomorrow I'll provide.
So
Then we'll
the
conclude it on Wednesday.
the citations will be provided
You have
tomorrow.
misunderstood, the matter will be coming on Friday, my lord. But yes, if the plaintiff, the petition,
Wednesday it will be heard. You
we
will
will
have.
continue.
No, I've finished. I'll
Sir,
just cite the
completed.
judgment.
I'll
I'll
do
finish.
arguing the matter.
So authorities will be provided.
By tomorrow.
By
morning, we will
tomorrow.
conclude on
Yes.
Wednesday.
একটু নম্বরটা দিয়ে দাও ভাই।
Yes.
নম্বরটা দিয়ে দাও।
As item number 150.
Grateful.
On Wednesday.
Wednesday at the top.
Being part heard. ঠিক আছে? ওটা part heard. আচ্ছা, in.
My lord, one indulgence, my lord. Wednesday can be 2 p.m. If my lord possible.
Kindly do not pray for that because
My lord, I'm grateful.
next.
I am for the respondent. Vinod.
The formula paying for this week time, I'm for the petitioner.
Yes, you start.
My planet senior has become a, can you see the order, name of the,
Yes,
he became a judge, we have to engage separate.
yes, that has taken place on Saturday. On the last occasion also, you had short
Separate
time.
time, only 1 week, this week time.
1
my
week
lord.
cannot be given.
Can
1
you,
week
Wednesday,
cannot be given.
may I come back on Wednesday? Lot matter has been hard, kindly see that last, two last order.
Matter has been heard.
The third one, 10th is been hard,
On 27th March. Yes, on 27th March. In the meantime, learned counsel representing the opposite parties undertakes not to proceed with the execution application.
My lord.
A favor has been done. Learned counsel,
But in the
don't
meantime,
take-
Lord, see, Saturday, my lord, this
kindly
has.
do not take undue advantage
No,
of the
I'm
favor
not.
being granted
I'm
by
not.
the learned counsel.
I'm not taking, my lord. I'll on one day, my lord, Wednesday or Thursday, my lord.
No, I am praying for vacating stay.
Yes, learned counsel, under the present circumstance, they are claiming seeking an adjournment and
On last
both
occasion, they also prayed for
witness-
adjournment.
yes, on that ground only. On that ground only. Uh, w- which day? Wednesday or Thursday? Which
Thursday,
day?
Thursday, my lord.
Hmm?
Thursday.
Learned counsel, Thursday.
To Thursday, Wednesday 12,
Hmm?
12, 12. Wednesday instead of Thursday.
My lord. As your lordship. As your lordship.
Nil. Wednesday. Nil.
Much obliged.
Mm, the learned counsel, the learned advocate representing the. You are representing. You are representing this one.
Mr. Tapas Datta is representing, and I am on behalf of.
She is my junior.
Yes. Okay. The learned advocate representing the petitioners seeks an accommodation for 2 days and prays for fixing the matter on 12th of August 2026. Full stop. Okay, full stop. Let the matter, consider the submission, let the matter appear on 12th of August 2026. But
That day, my lord, arrangement will be done, my lord.
as last
Last.
chance, as last chance. 12th of August, item number 2, as last chance.
Get
In this matter, I am for the respondent. The matter has appeared at my instance, madam.
Okay.
I am for the appellant lordship.
Hmm.
Can 2 of 2025 is pending. This is an application for substitution of appellant number 11 after setting aside abatement.
Seeking substitution of the appellant number 11. Okay, and 2 is pending.
May I submit, madam?
Hmm.
If your lordship's pleasure is to allow the substitution application, I have no objection. In fact, I have prepared paper book out of court, and the requisite copies have been served upon.
Let us incorporate, have the legal heirs incorporated, or are they already on record?
No.
No.
Lordship kindly takes up
Let the
paragraph
legal heirs be incorporated first.
Then it can be taken up for hearing.
Otherwise, it is ready.
Yes, madam. And it is a judgment of affirmance.
Paragraph 2, page 6, lordship.
Mr. Chakraborty, 1 minute. ছিঁড়ে যাচ্ছে। লিখে হবে না। দেখুন। ঠিক করতে হবে, বুঝলেন? এটা কিছু আপনি কিছু একটা ওই আইডেন্টিফায়ার দিয়ে দিন, যে এটাকে ঠিক এরকম দিয়ে দিলাম, ঠিক আছে? And 2.
Paragraph 2 at page 6, lordship.
এই যে ক্যানগুলোর হিয়ারিং হবে না, সেই ক্যানগুলোকে ওপরে করে দেবেন, বুঝেছেন? ক্যানটাকে ওপরে করে দেবেন। দাস,
Lordship. He died intestate on September 12, 2025,
Hmm.
leaving behind lordship his wife and two
Rithika
daughters.
Das, Sumita Das,
Yes,
Moumita Das,
yes. They are all major sui juris.
sui juris.
Yes. It is beyond 90 days, but within
150.
150. So, lordship, I have only prayed for setting aside abatement.
I have suit for.
Suit for partition and
Partition.
declaration.
You are representing all the
Yes, ma'am.
respondents?
Yes, ma'am.
Right. Then it's well and good. When can we commence?
Lordship, let the department carry out the necessary changes. Thereafter, Lordship, we can. Because, Lordship, the paper book is there. Since this is a second appeal, the other documents are not there. We will be making a compilation which will contain the plain written statement, everything. Otherwise, it may be difficult to go through the records.
No, if it can be commenced soon,
Yes.
then in that case, there won't be difficulty.
No, because, Lordship, the paper book doesn't contain plain written
I'll
statement.
have to go
everything.
through the trial court record.
Yes.
That hindrance can be overcome from this end. If it can be taken up tomorrow or day after tomorrow.
Just give us some 1 week at least, Lordship.
My lord,
So then in that circumstance, provide a compilation.
Lordship, we shall.
my lord, in the meantime, my lord, a copy of amended substitution is to be served upon me.
Lordship, as per appellate side rules, that is not there.
That will be incorporated by the
But the
department
department
herein.
will carry out the substitution. I have served him a copy of the substitution
So
application.
the substitution application has been served.
That has been served.
That is
My lord,
In
my
this
lord, very well.
situation, we don't serve it.
Can 2 of 2025. The learned counsel representing the appellants submits that the appellant number 11, namely
Rishikesh Das.
Rishikesh Das, has expired interstate on 12 September 2025. 12 September 2025, leaving behind his wife and 2 daughters as his legal heirs. She further submits that all the legal heirs are sui juris major and further submits that the said application seeking substitution has been filed within 150 days of the death of the said deceased. As such, seeks substitution of the legal heirs after setting aside abatement. Full stop. The learned counsel representing the respondents raises no objection.
Yes.
Raises no objection. Full stop. In such circumstance, let the legal heirs, that is the wife and 2 daughters of Rishikesh Das, since deceased, be substituted in place instead of the appellant number 11, since deceased. Full stop. Department to do the needful. এটা ডিপার্টমেন্টটা একটু বোল্ড করে দেবেন, ঠিক আছে? যেখানে প্যারা তো হবেই, বোল্ড করে দেবেন।
Lordship, both in the memorandum as well as there is a can in that also. For addition of party, there is a direction that it will be heard along with the appeal.
Addition of party.
Yes. I filed an addition of party in this honorable court.
My lord, may I submit my?
1 minute. Let me search out the can. Can. আচ্ছা শুনুন শুনুন, যেখানে না অর্ডারে ডিপার্টমেন্ট
8889.
যেখানে যেখানে মানে অর্ডারে ডিপার্টমেন্টটা ব্লক করা হবে না, ব্লক লেটারে থাকবে, সেটা দেখে নেবেন, ওটা পাঠিয়ে দেবেন ডিপার্টমেন্টে, মানে আপলোড হয়ে গেলেই ওটা পাঠিয়ে দেবেন। Can
Double
under-
one, double
to the
eight,
need-
9 of 2019.
That is the old number. The new number is 1.
11,889 of
Yes, and
2019.
Can 1 is the new number.
There was a direction dated 7th of February 2025.
1 minute. Please to issue a rule calling upon opposite parties to opposite party number 13 should not be added as an opposite party in the second appeal. Opposite party number 13. Who is opposite party number 13?
Ishwar Horihar Jiu Thakur.
In which paragraph?
Page 5, Lordship kindly sees.
আচ্ছা ওটা dispose of হয়ে গেল ওই ক্যানটা page 5 yes ঈশ্বর হরিহর জিউ ঠাকুর
My lord, in fact, the Sevait was sought for to be added, not the Horihar Thakur. That was my objection. Not the Horihar Thakur, the deity. The Sevait of the deity was sought to be added. That was my objection.
are they not incorporated?
Yeah.
The Shebite?
No.
Have you filed in written objection?
In
Yes,
fact,
yes.
yes,
You have filed.
yes. And all these questions be decided in the appeal matter.
A wide order number dated. No. আপনাকে না
7th of February 2020.
7th of February 2025 is the order.
এটা কিন্তু ওটা হয়ে গেল ওই ক্যানটা হয়ে গেল ঠিক আছে এখন আর এক্ষুনি দিচ্ছি না এটা হয়ে যাবে
7th of February 2025.
7th of February.
Memorandum.
7th of February. In order to prepare and file requisite manner and paper books, the want to pay the cost. The cost for the fund. As import the learner from appearing on behalf of the parties. And the fact that the prayer of the instant application involves substantial question of law. Acha. Paragraph number 2.
Yes.
Appearing on behalf of the parties. And item on the fact that the prayer of the instant application involves substantial question of law identical with that of the appeal pending before this court. And accordingly both have prayed for hearing. And accordingly both the learned counsel have prayed for hearing of this application being Can 1 of 2019 be taken up for hearing along with the appeal.
Right.
So on consent of both sides. It is.
Yes.
তাহলে নিন এবার চলে আসুন anything further to be submitted?
No, so Lordship, the substitution has to be
Substitution
carried there also.
has taken place. Acha.
No, in the application
In
also.
the application also. তাহলে দেখুন তো ওই যে to the needful department to do the needful both in the memorandum of appeal and the application being Can 1 of 2019.
Lordship.
Can 1 of 2019. Full stop. এটা হয়ে গেল ওই পোর্শনটা হয়ে গেল এইবার as the present appeal is otherwise ready for hearing, so on consent of both sides, let the matter be fixed on
Lordship, apart from 17, any day, Lordship, next week.
18.
Yes, yes.
Not kindly,
Tuesday,
Tuesday.
18, Tuesday. এটা এটা কি বলে হ্যাঁ under the heading hearing, under the heading hearing ঠিক আছে না under the heading hearing শুনুন এটাকে যেটা হয়ে এলে আপলোড হয়ে গেলে এটাকে ডিপার্টমেন্টে পাঠিয়ে দেবেন নিয়ে এসে এটা থাকবে টিউসডে হিয়ারিং থাকবে মানে টিউসডে উইক
Tuesday week, my lord.
18th Tuesday week.
Let put
It is good.
Item number 5.
Nitin. Item number 5. Neither the petitioners, neither the petitioners nor the respondents are being represented. In such circumstance, the matter cannot be taken up for hearing. Taken up for hearing. Let the matter appear on এটা কি বলে আজকে তো 10 তারিখ তো তাই তো let the matter appear on 14th দরকার নেই 13th let the matter appear on 13th. Next.
Item number 6.
I'm for respondent number 6. There was direction for filing a report, my lord. My lord, for my personal reason, I could not attend last week my chamber. They have contacted respondent number 6, the Pradhan. Only 2 weeks if given, we will complete and file report. I have been suffering from fever, my lord. That is why I.
On the you are representing
Panchayat Pradhan, respondent number 6. Direction was upon me to produce a report.
yes Kamrabad Gram Panchayat.
Yes, my lord. Already hearing conducted, my lord.
Pradhan is- After several attempts, the
For the first time, my lord, I'm asking for this extension.
just let us have the entire story. Thereafter, we can assess the conduct of the
Sir, for my
respondent number
personal
6.
reason, my lord, I've been suffering from. That is why failed to prepare. my
Let me complete. Then you will agitate whether you are aggrieved or not. The petitioner had made several attempts to serve upon the Pradhan.
On every occasion, they have received it.
His all attempts had been futile. This is writ petition of 2023. And ultimately, on 24th of July 2026, the Pradhan has been kind enough to appear before the court.
I have been engaged. I understood this matter. Just 2 weeks time, if granted, we will complete it.
As
No,
last
already
chance,
hearing
as
as
last
last
chance.
as
No further time will be granted.
no further. time.
Nil.
Already hearing conducted,
Nil,
just
nil,
report
nil,
needs
nil.
to be prepared. এর মধ্যে complete করুন।
একটা কপি দিয়ে দিন
নাম্বারটা
the learned advocate representing the respondent number 6, that is Pradhan, Amrabad Gram Panchayat,
কোনো ব্যাপারই না
seeks an accommodation for fortnight to file
report.
a report in the form of an affidavit.
In the form of earlier, it was not in the form of affidavit. In the form of
In the form of an affidavit, because 2 weeks is being
for
granted.
my personal reason, Lord. They
In
have
the-
contacted me.
In the form of an affidavit, what is the hindrance in filing in the form of an affidavit? In the form of an affidavit, কি হলো sentence টা? আচ্ছা, fortnight to file a report. ঠিক আছে, full stop. Consider the submission of the learned counsel. Let the report be filed in the form of an affidavit. Today is 10th. Let the matter appear on 24th. As last chance, full stop. No further time will be granted in this regard.
My lord, oblige.
Let the matter appear on 24th. ঠিক আছে?
No.
Next,
Item number 7.
I'm appearing on behalf of the Havra Municipal Corporation. Havra, HOWRH. Havra. Kindly seize the last order, Your Lordship.
gone through the last order.
Yes.
Learned counsel, special chance is being granted. On that day, necessary order shall be passed. Nin.
But so many times as it is reflecting from Your Lordship's own order.
That has been noted down
Yes, kindly. This is 4 occasions.
because of change of circumstance. Earlier, this bench was the learned counsel, Howrah Municipal Corporation. The Howrah Municipal Corporation is being represented, but once again, none is representing the petitioner. Full stop. White order dated through the early order. White order dated baad diye din. Through the earlier order, it was directed that the matter will appear as last chance, but considering the change of circumstance, let the matter appear once again on let it appear on 17th, as special chance, 17th, 17th August 2026, as special chance, full stop. On that date, if none represents the petitioner, then necessary order shall be passed.
Item number 8.
Grateful, Your Lordship.
8 Lordship, Mr. Pinkol Bhattacharya is appearing for the petitioner, Lordship. He is on his legs before courtroom number 25. I am praying for only not today, Your Lordship.
Why not today? The entire after recess, the entire session is left.
Lordship, one matter is going on courtroom number 25. Upon instruction, Lordship, I am just praying for only not today.
তোর ফকরার দাম আছে?
Sir.
Can
Only
I
not
tell you the
today.
last order? ফি তো করতে হবে, মামলা রাগ হয়েছে। After the matter is over, I have another submission. At 2, live streaming is off. Yeah. On. Not right. Many courts live streaming has been off. And I can remember Justice Siddhartha Rai Chaudhary, if I enter into the courtroom, live streaming obviously has to be off. Even if not my matter is not going.
Does that signify anything good?
Yes, because I've given instance on live streaming. On live streaming, nothing serious. It is on live streaming. One Punjab and Haryana High Court judge.
Number 4. As number 4, Suhasini Constructions submits that an order of demolition that has been passed by the Midnapur Minister in the state of construction, which is in contention in this present petition, and against the said order of demolition, judicial in this case been preferred before the Court of Civil Judge Junior Division. Order of demolition has been sent. The order be furnished during the course of this day. Petition. Has that order been furnished?
I have handed over to the last occasion. You also can recall. That is probably in the file.
Hey, দেখুন এরকম খোলা
It's like this, my lord.
না খোলা দেখুন সব খোলা দেখুন এগুলো সব খোলা এরকম
ছোট কিছু
বেরিয়ে যাবে দাঁড়ান এটা যখনই নামাবো তখনই ঠিক করে নেবেন।
I have handed over to you. That is there. আরেকটা কপি এটা আরে এটা কত কপি দে ওকে কপি এই তো খালি পেরিস দিস ওকে
একটা copy.
এগুলো কপি দিয়ে দেবো।
Mr. Basu, can another copy be handed over?
Just now handed over to my lord?
Yes. That is being provided to the court.
Certainly.
Achha.
If court asks something, I will not.
Because
I'm not so dare.
Yes, I am unable to paste that copy. শুনুন এটা কিন্তু ঠিক করে রেখে দেবেন এটা যেন হারিয়ে না যায়। Let a copy of the said order be
Must be in the file. It is not been.
Let a copy of the said order furnished during the course of this after serving copy of the same upon the donor advocate. Direction ছিল The learned counsel representing the petitioner submits that till date he does not have the information as regards to the stay or any order being passed staying the demolition order and seeks an accommodation to have instruction in this regard. Yes,
Lordship, I'm not on record in this matter, Your Lordship. I'm just praying for
you are
not
not the
today.
advocate on record.
No,
Who is
Lordship.
the advocate on record?
Mr. Pingal Bhattacharya, Lordship.
না না ও নয়
Praying for not today.
অ্যাডভোকেট রেকর্ড ওই না অন্য কেউ আছে দেখি
Tomorrow.
read a source, my lord.
নিন নিন
অর্ডার হবে দেখ না
নিন নিন a copy of the order dated 23rd of June 2023 passed by the learned civil judge junior division first court Midnapur in judicial miss case 127 of 2023 has been provided. Let the said copy
Be kept with the record.
Let the said copy be kept with the record.
Already handed over to
Already handed over. Let the said copy be kept with the record. A copy of the same has already been handed over to the learned counsel representing the petitioner
on the earlier date,
on the earlier occasion. Full stop. এইবার প্যারাগ্রাফ ওনার নামটা শুধু ওনার নামটা নেবেন ঠিক আছে learned advocate representing the petitioner
holding the brief of Mr. Bhattacharya
seeks accommodation on the ground of his senior. Full stop. Prayer is considered and allowed. Let the matter appear tomorrow, that is on 11th of August. Learned counsel, no further adjournment.
Gotcha.
Acha.
Now, this matter has to be relegated because the order which has been challenged here, that is the first matter of appeal in the appellate forum. So this writ petition become infructuous.
Let us start
Yes,
the
yes.
hearing. Let them submit.
What hearing? Nothing to be heard.
এগুলো সবকিছু তাহলে ঠিক করে রেখে দেবেন.
Now, may I say something?
No, no.
I am tempted.
No, no, no.
But at 2, I will be moving on application in code number 3. Can you hear me? I am not saying anything else. In that matter, my lord, my grievance is that the road from GT road is very bad and it requires repair. If I succeed, my lord, I will take fees from all the beneficiaries. That is my submission. If I succeed there, I will charge fees from all the beneficiaries. And now we have at least 3 beneficiaries on that side.
Which road? The entire GT road?
Entire GT road, starting from the Bali.
Item number 9. Well, I applied for the corporation, my lord. Lordship kindly see Lordship's order on 24th of July 2026. Lordship kindly see Lordship's order.
Gone through on the same type of order has been passed in item number ওই যে যেটাতে last chance করলাম 17 দিয়েছি এটা item number কত 7 ওই same order হবে ঠিক আছে
I don't know which order. Your Lordship's order, item number 7.
The বলে দিচ্ছি the Kolkata Municipal Corporation is being represented but none is representing the petitioner. On earlier several occasions also, the petitioner had not been represented. As such, it was fixed as a last chance full stop. Due to change of circumstance, the matter is being, earlier it was irregular bench, this is a regular bench. As such, due to change of circumstance, this being a regular bench, let the matter appear on 17th as special chance, full stop. On that day, if nobody represents the petitioner, then necessary order shall be passed.
Well, at the top on 17th of August, logically, so many occasions I appeared before your lordship.
Yes.
Lordship, kindly be top of the list.
The other matters?
Other matters, lordship, this is very, it will take time only 1 minute.
Yes.
It will take time only 1 minute, lordship.
It will be taken up on that day and necessary order will be passed on that day.
Your lordship has already been stated that that is the last chance on 14th of June.
That's why
24th of July.
On the earlier occasion, it was an irregular bench. Now it is a regular
Now
bench.
lordship, you are on
That's
regular
why-
bench.
That's why it is being fixed on a specified date. Specified date on 17th. On that day, if they don't appear, then the consequence.
17th.
17th. Consequence will follow.
I'm good.
Next.
Lordship, I am appealing for the appellant.
In this matter, Lordship, I am appealing for the Lordship respondent number 3, 5, 7, 8, 9, 10, and 11.
Lordship,
Yes.
praying for 2 weeks time. Lordship.
No,
To
you start.
Lordship, kindly give Passover, Lordship.
In this matter, Lordship, the arguing counsel.
Passed over to Learned Counsel. Senior Counsel, do you have any? Are you in this matter?
Lordship, in this matter, we are for the respondent, Lordship. The arguing counsel, Lordship, has been elevated, Lordship. 1 week time, Lordship, we are praying, Lordship, kindly take it next as judgment and decree, Lordship, both.
When can you commence? At 2 p.m.?
Yes, Lordship.
Otherwise ready?
We need to
let them start.
Let them
You
start,
take-
Lordship. Yes.
You take note. You are for 3, 5, 7 to 11.
7, 8, 9, 10, and 11.
No,
Yes.
3, 5, and 7 to 11.
7 to 11.
And you are representing
1 and 2 later used to signature.
1 and 2. Did you appear earlier? Yes, on last year on 14th of November 2025, you had appeared. So, who will be arguing?
Lordship, the leading counsel.
At 2 p.m. Come prepared. Suit for?
Declaration and permanent injunction. Both court, Lordship, decreed trial court, Lordship, decreed in our favor. Appeal dismissed. Against that, Lordship, this second appeal was
It involves
Lordship, some false signature by way of that, Lordship. They have, Lordship, come into
signature in
LTI dispute is there. Signature by the Lordship original executor. Now, Lordship, the defend.
Come prepared at 2 p.m.
Lordship.
এটা Passover থাকছে 2টোর সময়।
Great.
আর you are ready? You are ready? And as regards to the other respondents,
Other respondent, Lordship, only 4.
4
4 is not appearing, Lordship. They are appearing for 1 and 2. We are 3, 5, 7 to 11.
Learned Counsel, kindly inform the Learned Counsel representing the other respondents, remaining respondents.
I'm trying to, Lordship.
The matter will be taken up at 2 p.m.
That's it.
Next.
Today, let them, Lordship, submit, Lordship, today.
Yes, you take note of
Yes.
the submission.
Item number 11.
Mr. Roy had made you prepared.
Yes.
So this is the opportunity. Grab.
We will
the
argue, Lordship, but some
grab the
days.
opportunity.
Yes. We will argue, Lordship.
In this matter,
Uh,
I am appearing for the appellant.
Item number কত?
11, Malad. 11.
11, yes.
This is a section 5 application is there along with in connection with the second appeal.
Section 5 application. You are for the
My Lordship,
respondent.
Mr. Somo Mukherjee is appearing on behalf of the applicant.
Hmm.
He's on his legs before courtroom number 36. I
Hmm.
pray for a very short Passover.
My Lord, today I don't have any brief because your Lordship regular beings will be sitting today. I don't have any. My Lord. So,
It has been notified, I think, on
my Lord,
Saturday only.
my
itself.
Lord, yes, Saturday, my Lord, notified the 8 new judges have already taken. Your Lordship kindly takes up next Monday, my Lord, because my Lord, affidavit of service is the,
Interregnum period?
my Lord, any date,
Tuesday, Wednesday.
Wednesday, my Lord, fix it up.
Why not tomorrow?
My Lord, tomorrow, my Lord.
How many days delay?
My Lord, brief is not with me, my Lord, junior has not come. Affidavit of service even with him.
So when to be kept? You are representing all the respondents.
Applicant, my Lordship. Applicants.
Applicant? In
No, no.
11.
Item number 11, my Lordship.
In applicants.
1 minute, 1 minute.
Sir.
Item number 11 is SAT.
So I apologize, my Lordship. It's not.
Okay.
I apologize, my Lordship.
So when can it be kept? Wednesday?
Wednesday or next Monday, my Lord?
No, no, no. Wednesday.
As your Lordship, please.
Hmm.
As your Lordship. I don't have. Because other occasions have appeared before your Lordship.
No, the fact is that is the advocate on record in court?
No, my Lord, that is the reason he has not reached as yet.
He has not reached. He is fit and fine.
Fit and fine.
Then it be placed on Wednesday.
Osit Kumar Bhattacharya.
Learned counsel representing the appellants seeks an accommodation for this day and prays for fixing the matter on 12th of August. Full stop. Accordingly, let the matter appear on 12th of August. এটা হিয়ারিং কেন আসবে এখানে?
In application, my Lord.
এটা হিয়ারিং এ কেন আসবে? ক্যান হিয়ারিং নয়, ক্যান অ্যাপ্লিকেশন আন্ডার
Yes.
ঠিক আছে? Under the heading application. হ্যাঁ, let the matter appear under the heading application. শুনুন, কোনো ক্যান থাকলে সেটা যদি হিয়ারিং থাকে সেটা অ্যাপ্লিকেশনে আসবে, ঠিক আছে? হিয়ারিং হচ্ছে ফাইনাল স্টেজ। নেক্সট।
Item number 12.
12, my lord, I am for the appellant, my lord.
What about your adversary?
My lord,
Had they entered appearance?
my lord,
Have they
before
been-
before this code he never appeared, my lord.
Have they been served?
Yes, my lord, I served 2 affidavit of service. I personally request him.
আচ্ছা,
Also,
আগের রেকর্ডটা কিন্তু গেঁথে দেবেন ঠিক করে, যেটা ওই কপি অফ দ্য অর্ডার ওটা গেঁথে দেবেন। নিন দিন।
affidavit service, my lord.
How many respondents are there?
My lord, he appeared all the respondents.
Huh? Lastly, they appeared, respondents number 1 and 2.
Yes, ma'am.
Appeared on 8th of April 2019.
Yes, thereafter, that's why I am submitting before this honorable court, he never appeared, my lord. I served the notice.
Lastly served on?
Lastly served on.
Why are you furnishing this one? This is of
Earlier
2024.
affidavit of service earlier.
What is the consequence of the service?
He received, my lord.
Wherefrom it will reveal?
But letter, forwarding letter of the learned advocate.
Achha. 28th of July.
Yes, my lord, 28th, last week.
The above mentioned matter has been taken up for hearing before the lordship. After hearing is also was pleased to direct the appellant to serve notice upon to that effect on the matter will appear on 31st of July. Nil. Let a chance be given. Once again, you serve upon.
Again, sir, kindly fix a date so that.
Is the learned counsel appearing in court?
Yes,
Is he
yes.
available?
He is available. Yes.
He's available.
Yes, yes, yes. I personally know him, my lord.
It is his endorsement only.
Yes, my lord. It is his endorsement.
When can it be kept? You'll have to file another affidavit after serving. When can it be kept? So that no dispute arises later on.
Next Monday, my lord, so that by this week I shall finish all affidavit, complete service and affidavit service.
Two affidavit of service have been filed. One dated 21st of June 2024 and the other dated 30th of July 2026. Full stop. Paragraph. On perusal of the affidavit of service dated 30th of July 2026, it transpires that the learned advocate, Mr. S.S.
Arifin.
Arefin, Arifin, has been served with the notice on 28th of July 2026. What did he respond after receiving?
But he asked
Does he have connection?
He will appear. Last week he appeared before this court, but matter was not taken up. That's why.
Arefin has been served with notice on 28th of July 2026, and there is an endorsement to that effect. Full stop. In spite of receipt of the notice, the learned counsel is not representing the respondents today. Full stop. Paragraph. In such circumstance, let the matter appear on 17th of August 2026, as has been prayed for by the learned counsel representing the appellants. Full stop. Paragraph. The learned counsel representing the appellants is requested to serve afresh upon the learned counsel, or would you like to serve upon?
Well, learned counsel, I have
the learned counsel representing the respondents, and to file an affidavit in this regard on 17th of August. Full stop. On that day, if none represents 17th of August. What is the address of the respondents?
Address, my lord, Purva Bardhaman.
Only two are there.
Two are, yes, my lord. So, we shall serve also notice upon the.
I think it will be better.
All right, my lord.
You serve upon the learned counsel
as well as
by tomorrow.
Yes.
And also parallelly take another step in respect of the
respondent number
respondents.
1 and 2.
So will it be 17th? 17th will suffice.
Yes, yes, yes. Probably so.
The learned counsel is further requested to serve notice both upon the learned counsel representing the respondents and both the respondents.
Respondent
To
one
file
and two.
an affidavit
Yes, to
of
them.
service on 17th. Yes. Next. After recess.
My lord, before rises, I ought not to have mentioned, my lord. Item number 16 and 18. And 18. Well, I am for the both the matter. I am for the appellant. I am otherwise ready, but today I am not feeling well. That's why. My lord, on next Wednesday. On next Wednesday. Day after tomorrow. Yes, my junior will be here on the day after Wednesday. Yes, yeah.
My lord, my senior was mentioned before your lordship's item number 16 and 18 the day before.
Item number 10.
10, my lord, I beg to appear for the appellants, my lord. My lord, in this appeal, my lord, may I, my lord? My lord, kindly, before that, my lord, may I place an order, place a order? A order taken. My lord, order dated 25th 11/2025. My lord, passed in that SAT, that the SAT my lord is asking to me, my lord. That SAT in respect pending before the another bench. Because, my lord, in this appeal, what has happened, my lord, initially there were 5 defendants who preferred the first appeal as a 5 appellants.
1 minute. Partition suit?
No, my lord. Suit for declaration and injunction.
Suit for declaration and injunction. 1 minute. You are the appellants. You are for the respondents number P5, 7 to 11. 7, 8, 9, 10, 11. And you are for 1 and 2. 1 minute.
Who are the, my lord, plaintiff in the suit court.
Trial court.
Trial court.
1 and 2. And what about?
My lord, 1 got expired during pendency of appeal.
What about the respondents number 13, 14, 15, and 16?
13, 14, 15, 16 is the respondent who are appellant in, my lord, SAT 356 of 2017. My lord, may I first place the facts, my lord, because something has happened in this record. What has happened? Initially, my lord, the appellants in SAT 356 is a principal defendant in the suit court. They lost the suit.
1 minute. Yes.
Because
এখানে না এখানে শুনুন মেমোটা উপরে থাকবে বুঝেছেন বলে দিচ্ছি নাহলে নোট করে নিতে পারেন
yes, yes, yes. At the date Ram Prasad model. These are the 4 appellants before your lordship. But subsequently, that rectification was done pursuant to your lordship's direction. Lord, it was corrected because the Wakalatnama was executed in the department. They were not initially accepted my Wakalatnama. Then your lordship passed an order. I don't know, my lord, department whether corrected it or not. My lord, that would be reflected in the order dated, my lord, order dated 22nd May 2024.
Yes. Then I will.
My lord, 22nd May 2024. My lord, first paragraph, the discrepancy recorded. Accept the Okala. Okay. That was no incorporation. My lord, meanwhile, my lord, I will do that correction, my lord. I now, my lord, thereafter, what has happened, my lord, kindly take the next order sheet, my lord. Next order, that is on 10/7/2024. That is an adjournment not relevant, my lord. Order dated 2nd December 2024 has some relevance. Yes. My lord, on that order, on 22nd May 2024, we were granted liberty to take steps in respect of one defendant in a suit and one appellant in first appeal who left out in the second appeal. So, my lord, that person preferred a second appeal because, my lord, we said before this court that we will add him as an appellant, but the respondent, the then learned senior advocate, was opposing that. My lord, the appellant in SAT 153 of 2024. The second appeal. My lord. Devo Prasad Mondol. Now, my lord, in that, no, my lord, what has happened? At the time of hearing of section 5, my lord, kindly take the next page of that order, which I handed over just now to your lordship, order dated 25/11/2025. At the time of hearing of section 5 application, my lord, the learned advocate of the respondent number 1 to 10, who is, my lord, the respondent number 3 to rest of the appellant, a respondent in the present appeal. Now, my lord, they raised an objection that appeal is not maintainable in view of section order 41 rule 20. And, my lord, accordingly, liberty was granted to us to take out an application before the in connection with the appeal, which was already pending, which is, my lord, SAT number 356 of 2017. Accordingly, my lord, this can has been preferred, can 4 of 2025, to add him as an appellant in that SAT appeal. Kindly take, my lord, page number 2, internal page. Upon hearing of the learned advocates and considering the facts of the case, this court is of the view that the appellant, my lord, present appellant, should be granted a reasonable opportunity to make necessary application in the pending appeal, which is SAT 356, which is being heard by a learned coordinate bench of this court. Now, my lord, my submission is that, subject to their submissions, my lord, unless that person, my lord, be arraigned as an appellant in the 356, my lord, my appeal practically, my lord, 2 appeals are pending. If 2 judgments is being delivered, my lord, both will be contrary to each other. Can 4 of 2025, which is perhaps in the record of your lordships. Parties. My lord, I have stated paragraph regarding, my lord, left out part. My lord, paragraph number, yes, my lord, paragraph number 11, 12, and 13. Because that order, my lord, I have annexed in the can 4 as well. And the initial part where, my lord, he was left out is mentioned in paragraph number 8 and 9. My lord, may I read it? Because, my lord, that person suffered a degree. If my lords please to allow my appeal, then the degree will be remain against him, unless he is being added as the appellant in this appeal, my lord.
No, lordship.
My lord, copy served. My lord, last time it was recorded that they did not intend to file any opposition. My lord, order dated 12/12/2025.
7 to 11. 1 and
subject to correction, according to the order sheets, my lord, perhaps my learned senior is also representing 4, 5, 6 as well. Because 4, 5, 6, my lord, is the legal
not
year
for
of
the
5,
5,
6.
6.
এই যে এইখানটায় দেখুন লেখা আছে এই যে রেসপন্ডেন্ট নাম্বার 6 so and so passed away, then বলেছে legal year 3, 4 and 5 who are the sons, while respondent number 7 are daughter of the তাহলে তো বাকি সবকেই আপনি করছেন মনে হয়।
We are not representing lordship 6 as per our instruction, lordship.
6 মারা
6,
গেছে।
now the legal heirs lordship in Devaprasad Mondol. Now lordship, regarding lordship addition, let them added as a lordship party respondent because appellant status respondent.
Morning.
My lord is looking can 4. My lord, can 4 respondent, my lord, is the appellant in 356. So, my lord, to that extent, we will also represent him. My lord. My lord, may I break, my lord? My lord, 350. Respondent number 1 and 2. Yes. Poncham, yes. Gaur, Soil and Sonkor, perhaps.
Seven, 8, 9. 7 to 11. 11. Not 11. 11 is lordship. Tiloka Pal, up to Tiloka Pal. Because lordship application is because as per the lordship memo, lordship, it is defective because in the application number 11 is state of West Bengal. In the memo, lordship 12 is the state of West Bengal.
Yes, because my lord, respondent number 6 then was alive, subsequently died. Her legal heirs already been in the record, so 6 has to be deleted. By your lordship's order, 6 was deleted. So, my lord, the serial number obviously, my lord, would be 1 less. My lord have passed an order that name of the 6 should be deleted. My lord, kindly take the order dated 22nd May 2024. Internal page 2. As the respondent number 6, Vice Sorola Mondal has expired and her legal heirs are already on record, so the name of the deceased respondent be deleted. That is to be carried out in the paper book. পেপার বুকের পরে স্যার মারা গেছে আমরা খবর পেয়েছিলাম না মেমোতে হয়নি ওটা তো ডিপার্টমেন্টই মনে করবে না আমরাই করবো
নোটেড বলা আছে নোটেড বলে দাঁড়ান 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 ক্যান নট who was deleted
my lord the Sorola Mondal respondent number 6
করেনি নোটেড এখানে বলা কিন্তু কোথায় মেমো অফ অ্যাপিলে কোথায় নোট করা আছে এই দেখুন এটা মেমো অফ অ্যাপিল কি বলে সরলা মন্ডল ওই রেসপন্ডেন্ট নাম্বার 6 ডিলিট করা আছে করা নেই এটা করিয়ে রাখবেন দাঁড়ান নিন Let us proceed
Well,
step
my
by
lord
step.
granted me liberty, I will, my lord, correct that 6 as well as that at the date part. As my learned senior said that I can do it because my lord,
Can it be done by his?
Has to be done by the department.
Has to be done by the department.
Difficulty, then my lord can grant leave. Or else kind.
If there is no opposition, then in this regard,
Who will know?
We don't.
তাহলে শুনুন লিখে রাখুন wide order dated 22nd of May 2024. The original respondent number 6, namely Sharona Mondol, the name of the original respondent number 6, namely Sharona Mondol, was deleted, having been expired. But there is no endorsement to that effect in the memo of appeal. Full stop. The paragraph. The learned counsel representing the appellant or appellants is directed to do the needful.
as well as my lord in Ram Prasad.
Is given the liberty to do the needful in this regard. Or full stop. Paragraph. Or Ram Prasad.
By the same.
And as regards to the name of the appellant number 1, appellant number 4, the name of Ram
Prasad Mondal written in the memo, but his original name is Ram Prasad.
The name of Ram Prasad Mondal be added as alias in addition to Prasad Mondal. তারপরে দিয়ে দেবেন the learned counsel representing the appellants is at liberty to do the needful during the course of this day.
In the memo of appeal as well as in the paper. Meantime, paper book got filed also.
In the memo of appeal as well as in the paper book. আচ্ছা
learned
in the
advocate on record.
ওটা learned counsel বলেছি, learned counsel না, ওটা হচ্ছে learned advocate on record. Is the learned counsel is the learned advocate on record available?
Yes.
So during the course of this day, হলো এবার thereafter any technical?
No, my lord, then can is pending, can 4. And my lord, then I have to come up with an amendments paper, amended paper. My lord,
that is ঠিক আছে, এটা কত ডেটে হলো? This is formality.
Direction for circulation of the amended paper.
কি বলে the learned advocate representing the appellants is directed to circulate amended copy of the paper book. Full stop. But if Mr. Banerjee, if that direction is there, then hearing cannot be taken up.
No, can't happen today. Can't happen.
Because you are not ready.
I am ready.
You are ready.
But they were in the midst of making their submissions. Today, I believe my learned friend.
If this order is not there, the last portion, then we can proceed.
They can proceed.
My can is pending, can 4 of 2025. That person needs to be, if at all my lords allowed my application.
Okay, he is to be added.
So add him as a party.
Do you have objection to the addition of?
No, party respondent, if he added, subject to correction, my lord, my submission it is, if he added as a একজন appellant, sir, principal defendant,
He was there before the trial.
first appellate court.
He was before the trial court and before the first appellate court.
But
Somehow, according to his as per his submission, the name of the person is Devi Prasad. Devaprasad.
Yes. Brother,
Devaprasad was the
defendant in the suit.
Defendant number,
my lord. If from the decree it would be evident. The defendant number 5.
Defendant number 5.
Page 39 of my can appeal. 38,
Defendant
38.
number, yes.
Page 38.
Page 38.
Decree of the trial court.
He contested.
Yes.
Sir.
Defendant number 5
Yes.
before the trial court and
First appellate court, my lord, the decree that at my lord page number 71. Appellant number 5 in the first appellate court.
71.
Page 71.
Appellant number 5 before the first appellate court. So I don't think there will be any objection. Should not be.
No.
Kali, do not record our cells.
এবার তাহলে can no subject to learned counsel. Subject to proviso.
My submission would be that
Proviso, you start the hearing today.
my lord, I will
Yes.
take time because I
No.
by Mr. my lord Arijit Bordhan, my lord. What has happened, my lord? My prayer is before your lordship in respect to that application to add him as a party appellate, because they are giving my lord, no objection in respect of a respondent. Because my lord, subject to correction, if I add him as a respondent, he will still suffer the decree. Because the decree is against him. That's the reason, my lord, he was preferred the second appeal before.
Can a plaintiff ask someone to be added will it as a plaintiff? Well, that can never happen.
My lord, that's
If he
the
does
reason,
not
my lord,
wish.
Mr. Bordhan wants to make some submission before this court if date
In law, how
no,
can
my
he
lord,
even
in
make some
order
service?
4120, rule 20, it says that with a leave of the court we can. My lord, that was the argument. My lord, that can no, he can't be. My lord says that jor koreo korche. My lord, he intend to, because otherwise he was the appellant in the my lord.
Then in that circumstance, that person
May not be.
had to come up with the application to be added as an appellant.
At his research, he is going to be added, has to be added as a respondent.
As per,
then my lord, he was not.
If you intend to add him, then he will come under the category of respondent. And if that person intends to come and join as an appellant, then
my
it will
lord,
be considered.
I need to withdraw that application because that person need to take an order 1 rule 10 to add as a party in the appellate, because he was not a party to the main appeal in my appeal, my lord. Because my lord, he already preferred a second appeal before another bench. In that bench, they the respondent number, my lord, 3 to 1 to 11 objected that, and they said that this person
the court has expressed the view. Now it is up to you,
my lord. Till today, my lord, I will come back tomorrow. Let me, my lord, have a talk with my senior, my lord. Kindly consider the aspect, my lord.
তাহলে কতদূর হলো? শুনুন, না ওই শুধু ওই you delete the name, you correct by deleting the name of Sorola
Mondal, as well as that
and add
Ram Prasad Mondal,
alias Ram Prasad Mondal in the memo of appeal, and
as well as the paper book.
And the paper book, and furnish a copy to them, to all the 3 sets of learned counsels.
And well, the LCR, I believe, has arrived.
Yes.
Trial court record.
Yes.
Trial court ache, first appellate court ache. Have you gone through the were there any documents?
We will go through, but it was not known to be that LCR has arrived.
So kind enough to go
today's order that LCR has arrived. That should be kept with the record of this appeal. We will go through. Kindly grant us liberty.
It was recorded. The trial court record. Yes. আমি দেখিয়ে
তাহলে
because আমি সার্টিফাইড কপি নিয়েছি তো মাই লর্ড।
এইবার তাহলে the learned counsel representing the appellants seeks an accommodation for this day.
My lord, I will
tomorrow it will be taken up.
Yes, my lord, I will come back with.
And the court has expressed its view.
My lord, because my lord, if I want to add him as an appellant, then I have to withdraw and will come up with a fresh application.
Then I think in that circumstance,
if he comes up, my lord,
nothing is serious.
We not have it. But he.
Why may? Why the word may?
We shall not have that.
You know? For this day, full stop, considered and allowed, let the matter appear on 11th of August,
My lord.
2026.
So tomorrow, my lord will kindly allow me, my lord, to appear virtually. My lord, I have. আমাকে একটু জ্ঞান ফুটের একটা কপি দিন না
স্যার আমি করে দিচ্ছি আমার
কিছু করে দিতে হবে
আচ্ছা এটাই নিয়ে নিন আমার কাছে এক্সট্রা কপি আছে
থ্যাংক ইউ
একটু রেকর্ডটা দিয়ে দেবেন, ঠিক আছে? রেকর্ড এটা মেমো অফ অ্যাপিলটা ওনারা ঠিক করে দেবেন, ঠিক আছে? আর ওই
হ্যাঁ আমি দেখে
ওনাদের learned counsels be kind enough to go through the trial court and the first appellate court records today.
record that LCR has arrived. Kindly grant us liberty, my lord, to apply for certified copy and get it, my lord, in case anything is required. Liberty is not required as such, my lord, we are entitled to it. Very good. Now, my lord, we are hopeful that the appeal would move now.
We are, my lord, representing the appellant. It's not that any time we got dismissed for default, then we come up with a restoration.
No.
Grateful.
Let effective steps be taken.
My lord.
My lord, one generation has enjoyed the interim protection. Let the second generation not.
Grateful.
Grateful.
Never.
My application, Lordship. Can number 4.
Who are for the respondents?
We are for the pro forma respondents, Your Lordship. This is my recalling application. For recalling of order dated 22nd January 2024. By virtue of this particular order, initially we were appellants, Your Lordship. But by virtue of this particular
Learned
order,
counsel, the application is not being taken up now because in the absence of the other side, it cannot be taken up.
we have served, Your Lordship.
By the order dated?
By order dated 22nd January 2024.
22nd January.
It's at page 10, Your Lordship, of my CAN application. We can serve them a notice.
Yes.
Your Lordship.
What was the order passed?
Yes, Your Lordship would see the relevant para is at page 11. The third para. Considering the fact that the learned counsel appearing on behalf of the respondent does not oppose the said prayer seeking setting aside of abatement by condoning delay and substituting Rajiv Thomas and Ronojoy Thomas in the category of pro forma respondents. As such, the application CAN 3 of 2023 is allowed. So we are for Rajiv Thomas and Ronojoy Thomas. We are the sons of the original appellant, Your Lordship. After her expiry, we were not being communicated any information.
You have filed an application.
Yes, this application we have filed for recalling. CAN 4, Your Lordship. If Your Lordship pleases, we can serve a notice upon the opposite party.
CAN 4?
Yes.
দাঁড়ান যে অ্যাপ্লিকেশনটার হিয়ারিং হবে সেই
Yes, Your Lordship. We can serve a notice again, Your Lordship. Yes, page number 5, Your Lordship. Recalling. of the order dated 22nd January. Yes, Your Lordship. The ground that we have taken, the advocate the advocate who was representing us at that particular point of time did not communicate anything with us, and that advocate has on his in his own capacity has taken out that application by which they have transferred us to the category of pro forma. That is our ground, Your Lordship, because it was,
Can it be?
Your Lordship, it was,
According to law, can it be?
yeah, Your Lordship, I'm carrying a judgment.
Whether that learned counsel
Yes.
had the wakalatnama on his behalf on that day or not?
He did not, Your Lordship. I'll indicate why, Your Lordship.
So if this be your allegation, then that learned counsel will also have to be served. Am I clear? So you serve the copy of this application, Nin.
Very well.
ওনার নামটা নেবেন, learned advocate. Have you filed wakalatnama?
Yes, yes, Your Lordship.
The learned advocate representing
Former respondent, Your Lordship.
Rajiv Thomas and Ronojoy Thomas, the pro forma respondents, submits that an application being CAN 4 of 2026 has been preferred, seeking recalling the order dated 22nd of January 2024, whereby the petitioners, namely Rajiv Thomas and Ronojoy Thomas, have been incorporated as pro forma respondents. Full stop. As none is representing the appellants or the respondents number,
Appellants
and the respondents, Anjana Thomas has expired.
We are the heirs of
Heirs of Anjana Thomas.
Anjana Thomas was the original appellant.
Appellants, none is representing either the appellants or the respondent full stop. None is representing either the appellant or the respondent. In such circumstance, the learned counsel representing the petitioners is at liberty to serve copy of the said application afresh upon the learned counsel representing the appellants and the respondent, principal respondent, and the learned counsel who was representing the pro forma respondents.
Your Lordship, nobody was representing the pro forma respondents initially because they used to be the appellants. So, Your Lordship, what happened after the expiry of Anjana Thomas, they were supposed to serve as a substitution application, but they did not. So that because of this, we were never served with a copy of the substitution application. So what they did, they deleted the name of Anjana Thomas and they transferred us to the category of pro forma respondents. I've taken this ground, your lordship, para 7.
Acha. At that relevant point of time, till death of Anjana Thomas, she was one of the appellants.
Yes.
So this learned counsel who was representing the appellants
Yes.
was also representing Anjana Thomas,
Yes.
and the order dated 22nd of January 2024 was passed on the submission of the learned counsel representing the appellants.
Yes. By 22nd
Let them come.
Very well, very well.
Let a copy of the said application, let the copy of the said application be served upon the learned counsels representing the appellants and the principal respondent, and to furnish an affidavit of service on the next date.
Grateful.
Actually, যাচ্ছে। Let the matter appear on. When can you serve and come? Including affidavit of service.
Your lordship, it can be taken up next Monday, 17th, your lordship.
Let the matter appear on 17th of August 2026.
18th, your lordship, instead of 17th, 18th.
18 করে দিন।
Grateful, lordship.
18. Next.
Item number 13.
None is representing either the appellant, none is representing either the appellant or the respondents. Full stop. On the earlier occasion, that is on 24th. আচ্ছা দাঁড়ান। আচ্ছা, on earlier several occasions, that is on 12th of November 2024. To 12th of December 2024. 12th of December করবেন, ঠিক আছে? 12th of December 2024, 28th of February 2025, 7th of November 2025, 14th of November 2025, and 24th of July 2026. Date gulo আরেকবার check করে দিন। 12/12/2024, 28/2/2025, 7/11/2025, 14/11/2025, and 24/7/2026. ঠিক আছে? আবার সেন্টেন্সটা বলুন কি হলো? হ্যাঁ, প্রথম থেকে none is representing either D, none is D.
None is representing either the appellant or
Mm,
the respondent.
mm, mm. On earlier several occasions, that is এই ডেট গুলো 1 2 3 4 হলো। None had represented either the appellants or the respondents. Full stop. For the ends of justice, let the matter appear on 17th of January, 17th of August, 2026, as last chance, full stop. On that day, if none represents the appellant, then necessary order shall be passed. Next.
My appeal. I am appearing on behalf of the respondent, my lord, R.P. Motilal. He has not come to the duty illness, my lord. I pray for simpliciter application for substitution, my lord. The sole appellant has expired.
কত বললো দাদা?
15. And 15, I am appearing on behalf of the respondent. R.P. Motilal, he is appearing advocate on record, my lord. I pray for not this week, but due to illness, he has not come to the
Who is the advocate on record on behalf of the respondent?
R.P. Motilal. Dr. R.P. Motilal. R.P. Motilal, Dr. R.P. Motilal. Rudra Prasad Motilal. Yeah. No, it's a simpliciter application for substitution, my lord. I know, my lord. I'm just placing what it is, my lord. I leave it to your lordship. If your lordship is
17th.
17th, your lordship.
17th. On that day, if he is unable, then in that circumstance, make alternative arrangement so that the matter is taken up positively. Otherwise, it will be passed. The application will be disposed of ex parte.
Yes, ma'am.
নিন ওনার নামটা নিয়ে নেবেন। Learned advocate representing. What about the other respondents?
My lord, only
who is representing the other respondents?
My lord, those are performers, my lord.
অর্ডার বুকের বলুন প্রত্যেকটাতে এরকম হলে অর্ডার
আমাদের কবে দিয়ে দিয়েছো সব দিয়ে দেওয়া হচ্ছে লাস্ট দিন তো আমাদের কিছু এভরিথিং ইজ সোমবার একদম ডিরেক্ট সোমবার 7 দিন বুধবার
যদি না কাজ জানে তাহলে করতে হবে না। লুজ পেপার মানে কোনো ওই নেই, এটা যে দেখবে ঠিকঠাক ঠিক করে করতে হবে কিন্তু। ও দেয়ার আর the remaining 2 to 5B are pro forma respondents.
Yes, your lordship.
Learned advocate representing the respondent number 1 seeks an accommodation on the ground of the learned advocate on record representing the respondent number 1 seeks an accommodation for a week. On the ground of his illness. Considered, let the matter appear on 17th of August 2026.
Get your lordship. This matter was exhaustively heard by your lordship, and in the midst of it, the appellant expired, my lord. Your lordship will remember Mr. Gopal Chandra Ghosh appearing for the appellant, and Mr. Prabal Mukherjee was appearing on behalf of the respondent number 1. Judgments were cited, and we were in the midst of the formal argument.
It has been heard.
Yes, my lord. It has been exhaustively heard, my lord.
On 17th, Learned Counsel.
Yes, yes. Grateful.
Otherwise, make alternative arrangement.
Yes, grateful. Grateful.
My lord, item number 16 and 18. 16 and 18, my lord, senior advocate mentioned the matter.
16, yes, 16.
16 and 18, my lord, day after.
Learned Counsel mentioned only one. The matter which has been called, mentioned as regard to that matter only. Item number 16, Mr. On the ground of the personal inconvenience of Mr. Ghosh.
Mr. R.N. Dottu.
Oh, sorry.
Mr. R.N. Dottu.
Mr. R.N. Dottu. Okay.
Fixed on Wednesday, my lord.
It is an appeal. I am being led by Mr. Pratik Kumar Chatterjee, learned senior advocate. My lord, we have to contact the client as it is appearing after a long.
That is up to you, Learned Counsel. Yes, it is being considered and allowed. Let the matter appear on Wednesday.
Wednesday, yes.
Let the matter appear on Wednesday, 12th. Nin.
At 12 noon.
ওনার নামটা নিয়ে নেবেন learned advocate representing the appellant রেকর্ডটা দিল না মানে রেকর্ডটা দিন
My lord, it has been extensively heard on 20th of March by the respondent number 1 only. By us.
Representing the appellants seeks an accommodation for 2 days. Post up. Considered and allowed. Let the matter appear on 12/8/2026. That is day after tomorrow. Under the heading several applications. Can 1 of 2014.
Yes, my lord, it has been heard by you through us on 20th of March, my lord. You have passed an extensive order. On that, the petitioner was not, appellant were not there. And the next day, they prayed for an accommodation again.
Which application is pending?
No final order passed. No order passed on that.
Can you apprise the court which application is pending? Who is the advocate on record? Who is the advocate on record on behalf of the appellants?
Mr. R.N. Dottu. Mr. Priyabrata Ghosh, advocate on record, my lord. From the record, it shows.
Only can 5 of 23 is required to be disposed of. The other applications have become infructuous as per the order dated 20th of March 2026. Let the matter appear on 12th of August 2026. Nin.
Yes.
Under the heading application.
Item 18, same, my lord.
17 Dakun.
Item number 17.
Shona Bhattacharya and the senior counsel is not in position to appear in this matter. I am praying for not today.
Why he is unable to appear? Why he is unable to appear?
I have got instruction that she is not in position to appear today.
When he can appear? When he can appear?
Tomorrow.
ওনার নামটা নিয়ে নেবেন। Learned advocate representing the appellant seeks an accommodation for this day. The prayer is allowed, considered and allowed. Let the matter appear tomorrow. Date দিয়ে দিন 11/8. Next. Next. পরেরটা। এটা তো অ্যাপ্লিকেশন নাকি দেখি ক্যান কিছু তো পেন্ডিং নেই মনে হচ্ছে, নেই তো ক্যান আন্ডার দ্য হেডিং হিয়ারিং, আন্ডার দ্য হেডিং হিয়ারিং
Item number 18.
My lord, 18, I am for the appellant, my lord, I am paying for day after tomorrow, my lord.
Plenty to the trial court.
for the appellants.
Yes, my lord. Day after tomorrow, my lord, similar.
Learned advocate representing the appellants seeks an accommodation for 2 days on the ground of his senior. Accordingly, let the matter appear on 12th of August.
Grateful,
My
my
lord,
lord, grateful, my lord. दिया है नाम लेके दिया है ग्रेटफुल माइंड
Item number 19.
My lord, I am for the respondent. 20, yes. I am for the respondent, my lord.
For the respondents,
Yes, sir. I'm led by Mr. Haradhan Banerjee, and he's now the hospitalized. My lord, my praying for the 1 week adjournment. Well, maybe 19. If you under several occasions, the appellant is not appearing, my lord.
in the last 2 occasions.
Yes, my lord.
When can it be fixed?
19, my lord.
19th.
Yes, my lord.
নিন নামটা নিয়ে নেবেন।
Yes.
Learned advocate representing the আচ্ছা none is প্রথম প্যারাগ্রাফ হচ্ছে none is representing the appellants, full stop. Learned advocate representing the respondents seeks an accommodation for a week, for 10 days, seeks an accommodation for 10 days on the ground of his senior, stating that he is admitted in hospital, full stop. Consider the submission of the learned counsel, full stop. আচ্ছা ঠিক আছে, consider তারপরে লিখুন প্যারাগ্রাফ। on perusal of the paper book, it transpires that none had represented the appellants either on 2/1/2026 or on 24/7/26. Full stop. In such circumstance, paragraph, in such circumstance, let the matter appear on 20th.
Yes, my lord. Yes, my lord.
20th of
Okay.
August 2026. Paragraph. If on that day none represents the appellants, then necessary order shall be passed.
Yes, grateful. Deep grateful, my lord.
20th of August.
Yes, sir.
নামগুলো কিন্তু নিয়ে নেবেন বুঝলেন? Give your name only.
Yes, ma'am.
Item number 21.
None is representing. ওখান থেকে নিলেও হবে, অসুবিধা নেই, ঠিক আছে, যেটা তো সুবিধে। None is representing either the appellants or the respondents. Full stop. In such circumstance, the matter cannot be proceeded. Full stop. Let the matter appear on 13th of August. Full stop.
Item number 22.
I am praying for not today.
Why?
My learned senior is engaged in another court matter.
Learned counsel, let me be clear from this end. This was an irregular bench, but it has become a regular bench. Henceforth, such prayer won't be allowed at all. Who is the advocate on record?
Ms. Ravani Sarkar.
Hmm?
Ms. Ravani Sarkar.
You are seeking accommodation for 1 day.
Yes, ma'am.
Learned advocate representing the appellant seeks an accommodation for this day on the ground of the senior. Full stop. Considered and allowed. Let the matter appear tomorrow. On tomorrow বলতে let the matter appear on শুধু ডেটটা দিয়ে দেবেন. Let the matter appear on 11.
Item number 23.
Lord, 23, my lord, I beg to appear for the appellant. Your lordships, since today, my lord, is taking up this bench regularly, my lord, what I am humbly seeking, my lord, we seek expeditious hearing of the appeal, my lord. Kindly fixes a date, any day, subject to your lordship's kind sanction, we'll come prepared with the written notes and we'll complete the hearing. Any day, kindly fix it.
Hearing completed.
No, kindly fixes a date. My lord.
Come prepared with the written notes.
Lord, I am saying that kindly fixes a date, my lord. We'll come with the written notes and we'll finish the hearing on that day only. That's my.
I believe my learned friend would like to make the submissions before the court, arguing it. Pursuant to that, he will file the.
Yes, but kindly fixes a date. Or we'll come prepared and finish it off in one day.
If your lordship could kindly take up the record once, I was just wondering if everything is ready for hearing, because on 24th of April 2024.
24th of April.
Yes, there is a direction of L and OM as available in the official website, my lord. In pursuance of this case, a substitution was being carried on, and that is being allowed. Yes.
24th of April 2024.
24. the appellant passed away, and immediately thereafter they took a substitution application, and now that has been allowed. But pursuant thereto, yes.
But we can it transfer an office report that substitution application can see dated author has been filed subsequent to the death of the sole appellant. Mata Prasad Vijay.
Yes, he passed away.
He has expired.
He has
on,
expired.
On
that is already on record.
An application being CAN 3 of 2021.
Yes, it was
dated
taken up.
25th of February 2021 was filed. This further
And
stated
it
in
was
the
allowed
office
also.
report that
Allowed,
the
and
said-
1C have been already brought on record, Your Lordship.
1 minute.
Yes.
It is further stated in the office report that the said sole respondent, Pranab Bhattacharjee, sole
Yes, I am
respondent.
for the sole respondent.
He has also died.
No, he's alive. We had no objection because we were being served with a copy of the application.
I tell your lordship, the appellant had died.
I'll hear both of you exhaustively at length, but let me go through the order.
Yes, very
Do you have the copy of the order?
Yes.
Paragraph 1, 2, 3.
No, জজ সাহেব
4,
দেখতে আমাদের দেখতে
5,
বলছে
6. Order number 6.
Yes, accordingly the substitution is allowed.
Order dated 24th of April 2024.
Yes, passed by the learned registrar administration.
Paragraph 1, 2, 3, 4, 5, 6. It is further stated.
Yes, that the sole respondent. No, it should be the appellant. It's the wrong record. Yes.
So sole appellant died in state on 25/2/2021.
Now takes the next paragraph.
Sitting behind his legal heirs who are all major sui juris, and the application is filed within time. In view of the which is apparent that the application is filed after the death of sole appellant, which is within time and in consequence, accordingly, the substitution application is allowed.
Yes.
Ultimately, the substitution
Yes,
application
substitution has been
allowed.
But there is a subsequent order, Your Lordship, of 4th of December 2024. There was some there was a direction for removal of defects because some of the exhibits filed at the instance of the defendant ABC.
It transfers from the office report that trial court record has been received in connection with ejectment appeal number 5 of 2013 and rent control case 201 of 2005. And on examination of the same, it is found that the exhibits filed on behalf of the defendant. Who was the defendant before the trial court?
Mandai was the defendant.
Exhibits filed on behalf of the defendant being number A, B, C are absent in the file and the trial court record is incomplete. In view of the above, let the trial court record be immediately sent back to the Court of Learned Additional District and Sessions Judge, District Judge, 15th Court, Alipur, for removal of defect as indicated herein above with the direction to retransmit the trial court record. Yes. These are administrative orders.
Yes, these are administrative orders. Thereafter, my lord, the matter came up before your lordship. And my lord, on repeated occasions, my lord had given direction before the learned trial court that the record be sent.
Yes, sent back.
My lord, we don't know the fate whether the records are complete or not.
Yes. Otherwise, my informal paper books have already been
Informal paper books have been prepared.
Already prepared and exchanged.
If the lower court records have arrived, your lordship would kindly fix us a date for hearing.
দেখুন তারপরে অর্ডার কোথায় ঠিক অর্ডার বুকে এরপরের অর্ডার গুলো আর অর্ডার কোথায়
There should be a formal report from the department with regard to the
Is that the LCR is complete?
Absolutely.
The stamp they will give that endorsement.
Yes. Ready for hearing.
Mr. Banerjee, that's why you are so much confident.
No. My lord, I thought the lower court records have arrived. My assumption is that lower court records are.
I don't think so.
No, 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 my lord. Not that.
এগুলো তো রেজিস্ট্রার অ্যাডমিনিস্ট্রেশনের অর্ডার, কোর্টের অর্ডার কোথায়?
If I may just appraise your
Madam,
lordship,
দাঁড়ান
but pursuant to the order of, yes,
খুলুন তো ওই
Next.
এসে এসে না এসে টি
essay
এসে
118 of 2024. এটুকুই আছে।
হচ্ছে lower court record।
বেনিটা বলতে পারতো।
এখানে যে এসে হলো, এসে নাম্বার কোথায় এসে?
যদি পার্ট টুটা একবার দেবেন, ওখানে লেখা থাকবে NCR এসে
হুম,
গেছে।
হুম।
আরে এটা তো
না, না,
হচ্ছে
ওইটা দিন আমার।
কোনো এন্ডোর্সমেন্ট থাকবে
Endorsement থাক, হ্যাঁ, সব দেখি।
25
no,
Yes.
My lord,
Learned counsels,
Yes,
Mr. counsels, there's a report
yes.
Dated 10th of February 2026. ওটা আবার কি?
and my lord, on 18th of August 2025,
Hmm.
the office records
Hmm.
that the lower court records are found to be complete.
Yes.
It has also been recorded in order dated 10th of February 2026. It is further most humbly submitted that the connected trial court records were received, examined and found complete as per office note dated 18/8/2025. Oh, they are
That is-
banking upon that order dated 18th of August 2025.
Yes, yes, that my lord, I placed before.
Yes.
Kindly fixes the date.
In such circumstance, learned counsels go through the entire first trial court record and the first appellate court record
Yes.
today itself. When can it be? Paper books?
Paper books have been complete and we have served upon, my lord.
Paper book আছে?
নিশ্চয়ই থাকবে।
ফাইল করা হচ্ছে ডিপার্টমেন্টে সব।
এখানে এসে নাম্বার হয়নি এখন, হ্যাঁ? আরে পেপার বুক, হ্যাঁ?
Paper book nahi. My lord, may I humbly submit one thing, my lord? We have a copy of the paper books, my lord. On the day of hearing, my lord, I will.
We can produce it, yes.
Kindly fixes the date, my lord. In the subject to a lawsuit sanction.
Have you filed a thin paper book
Yes, very thin
without
paper.
hard cover?
My lord.
Without hard cover?
No, no, with hard
That
copy.
may be with hard cover.
Yes, we had filed. We had filed.
That can be identified.
Yes.
Sometimes there are,
This is the one.
ও না, দেখুন দেখুন ভালো করে দেখুন ওখানে আছে কিনা।
Oh, sorry, sorry. This is the one. এটা আট করা নেই।
নিশ্চয়ই থাকবে।
ডিপার্টমেন্টে তো সার্ভ করেছে ডিপার্টমেন্টে।
রেকর্ড গুলো কিন্তু একটু ঠিক করবেন, বুঝেছেন? যে এরকম হয় মানে টিরে টিরে যাবে না জানো।
My lord, kindly fixes the date, my lord. We'll
When can it be fixed?
my lord, any day subject to a lordship's consent. Kindly give this 10 days time, my lord. Well, 10 days, my lord.
What the court will do during these interregnum period?
Next week, any day next week.
Awaiting the learned counsels.
No, will not take me amiss, my lord. Kindly fix it any day next week, my
Which
lord.
date? Which date?
Any day.
Any day of the date.
17th, Monday?
তোমার অসুবিধা বলো। just আমার
20th will be 19th or 20th.
Why not 17th or 18th?
17th, I have a difficulty, my lord. I'll be out of station.
or 19th or 20th, any day.
Wednesday, 19th.
19th. Fair enough.
বুধবার ভালো দিন।
Every day is a good day, provided you win the case.
আচ্ছা, কি হলো? দাঁড়ান, কি বলে? দাঁড়ান।
ফর্মুলাটা করে দেখি, এগুলো আপলোড করেনি।
Mata Prasad Vijay has expired. He has been substituted by Joy Prakash Vijay. No, Gayatri Devi Why?
Lord, I believe.
The eldest son is elder to the wife. 1B is Gayatri Devi widow. Gayatri Devi Vijay. 1A is Joy Prakash Vijay. 1C is Asha Banerjee daughter. Apart from them, no one else. And Pranab Bhattacharya is alive.
Yes. Yes. Yes.
Okay. Nil. The learned councils representing the appellants and the respondent submits that the present appeal is ready for hearing. Full stop. On going through the order book, it transpires that the trial court, both the trial court record and the record of the first appellate court have arrived and are complete. In such circumstance, as per the prayer of the learned councils, let the matter appear on 19th of August under the heading hearing. It will be hearing. Go through the trial court record and the first appellate court record.
এখনই দিয়ে দিন, এখনই বসে দেখুন।
আর শুনুন ওই
এলসিআরটা দিন, ওই দেখুন দিদি একটা দিলেন একটু আগে আমার। ঠিক আছে। ওইটা এলসিআর, ওইটাই এলসিআর। এই চলো দেখুন। Maybe peruse the yes. Yes.
Item number 24, week 25. No,
Your Lordship, I'm appearing on behalf of the respondent.
Second appeal, my lord. My lord, since my lord, it's only section 5. My lord, the appeal, there is a 5 days delay.
I'm appearing on behalf of the respondent in 24 and 25.
So there is a 5 days delay.
Yes, section 5. Section 5 application.
Section 5, yes. After this, the matter will go before the Honorable Division Bench under Order 41. Yes. Yes. My lord, paragraph 4, my lord. My lord, since the delay is, my lord, 5 days, my lord, it is for that reason. More particularly, it is more particularly noted that reason was not given, man. Paragraph 4, my lord, there is every chance of success in the appeal.
Your Lordship.
Yes. 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 That should, yes. It is. Paragraph 2 and 3, that the appellant petitioner even filed application 7 on 7-2, which have been allowed to second bench. It is regarding merit that have deposited all it. My lord, it is during the period, my lord, when it was matter before my clerk concern, my lord. It is, my lord, for that reason it is.
There is, my lord, there is no opposition, my lord. So, my lord,
Your Lordship, my contention is, may I submit? My contention is their Section 5 application is uncorroborated with fictitious, malicious intention. They have not at all explained anything regarding their delay of 5 days. I am just.
let kindly see the stamp report of regarding delay. It may be less than 5, my lord. I think it's so, my lord. I was under my lord. It is up to your lordship, my lord. I am not insisting, my lord. Yes, admittedly, as per the stamp report, according to us, there was no delay. But as per stamp reporters, my lord, it was when it was handed over to my clerk. 16. Next week, my lord. 16 days delay. ঠিক টাইমে মক্কেল এলো আমাদের ডিলে হয়ে যাচ্ছে।
Your Lordship, kindly note my verbal opposition. Grateful. 16 days.
হ্যাঁ, একই হবে একসঙ্গে থাকবে। মক্কেলকে ডাকবো কি করে? আছে মক্কেলের নাম্বার টাম্বার আছে? করুন রাজকুমারের নাম্বার ডাকুন। No, my lord. Written, my lord. Morning.
Okay. Grateful, Your Lordship.
Item number 26 to 27.
Item number 26 and 27, Mr. Taraknath Haldar is appearing for the opposite party respondents. My lord, he could not come due to some personal difficulty throughout this week, my lord. I'm praying if it can be adjourned next week. My lord, I am not the advocate on record, my lord, in this matter. Perhaps, yes.
But from the order of admission, it will appear. Yes, Lord, your Lordship directed here by my Lord's. We have prepared paper book in view of my Lord's direction. And
Only this week he has some difficulty, my lord. My lord may keep next week. Yes, my lord, he won't come. That is what my instructions are from him. My lord. My lord, it's a. He won't be here for this week, my lord. I'm praying. Perhaps there is some difficulty, my lord. Yes, Lord, my lord, no, my lord. My lord, what? My lord, no, my lord, I am not. Telephone, yes, my lord.
my Lord, any Any day after 18th, my lord, I will not be there on 17th and 18th. 17th and 18th, I will not be there. Next week. My lord.
Right.
Go to leave, my lord, Calcutta. That's why. After 18th, my lord, any day. August, we are in April.
4th September. 4th September.
5th September is Teachers' Day.
Yes.
4th September.
No, we have nothing to do with it. Teachers' Day. It is not a holiday.
But 19th, Wednesday.
Yes, I have no difficulty.
Learned Council.
My lord.
On that day, there won't be any accommodation.
Very well, my lord.
This can be assured from this end.
My lord, I'll inform.
In that circumstance, an alternative arrangement shall have to be made.
Very well. I will inform him.
ওনার নামটা নিয়ে নেবেন।
ওদের
Learned
থেকে
advocate representing the you are representing all the respondents.
সবাইকে একজনই একটাই।
Lord, I am for the appeal.
No,
All the
respondents.
respondents.
Respondents are Sharat Kumar Gupta, Nilesh Sharat Kumar Gupta, Nilesh Sengupta, Dolly Shah, principal respondents, and there are 3 other pro forma respondents.
What are for the principal respondent?
Lord, they are representing the principal respondent.
Principal respondents. তাহলে দাঁড়ান এক মিনিট আগের অর্ডারটা দেখে নেবেন 1 to 3 Mr. Taraknath Haldar is representing respondents number 1 to 3 in both matters. ঠিক আছে এখানে দুটো আছে 26 আর 27 বুঝেছেন এসে একটা হচ্ছে 20 এটা হচ্ছে 20 2026 আর ওটা 21 যতদূর মনে হয় অর্ডার মনে হয় 20 তে হচ্ছে 21 এ হচ্ছে না মনে হয় অর্ডার তাহলে learned advocate representing the respondents number 1 to 3 seeks an accommodation for a week for 10 days stating that the learned advocate on record is indisposed. Full stop. Consider the prayer. Accordingly, let the matter appear on 19th of August. Mr. Ghosh, otherwise the matter is ready.
Yes.
Documents, the trial court record, first appellate court record, all are complete.
Yes.
ওটা হচ্ছে কবে 20 না 19 কবে 19th of August. Everything is over. All the documents are also there. Kindly come prepared on the next day.
Anyone will come.
Next.
Item number 28.
আচ্ছা ওই ডিসপ্লে বোর্ডের ডিসপ্লে হচ্ছে ঠিকঠাক দেখে নিয়েছেন তো none is representing either the appellant none is representing either the appellant or the respondent. Baba. তুলবেন না দাঁড়ান এমনিতেই এমনিতেই কি বলে হচ্ছি কাশছি এই অবস্থা ধুলোয় ভর্তি একদম বাবারে। বলছি respondent in such circumstance the matter cannot be proceeded, full stop. Let the matter appear কবে রাখবো বলুন তো না না সেটা না ব্যাপারটা হচ্ছে যে তাহলে কাল পরশু কি হবে কাল পরশু এগুলো পরের পরের গুলো তাহলে এই কন্টেস্টেড অ্যাপ্লিকেশন গুলো দিন তাহলে সিও বুঝলেন এই যে দেখুন এই যে আইটেম নাম্বার 45 46 47 48 এইগুলো এইগুলো আগে দিয়ে দিন ঠিক আছে হ্যাঁ এইগুলো এইগুলো তাহলে ডেট দিয়ে দিচ্ছি তো বরঞ্চ ডেট দিই তাহলে কবে দেবো 17 কত লম্বা দেওয়া যাবে না 20th let the matter appear on 20th of August তারপরেটা ডাকুন একই অর্ডার হবে শুধু দুটো তিনটে করে দেবো এক এক দিনে বুঝেছেন হ্যাঁ 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 তাহলে এটা 19th হলো তো 20th হয়েছে তাহলে ওটাকে 20th রাখুন এটাকেও সেম অর্ডার 20th 20 আইটেম নাম্বার সেম অর্ডার এরকম ডেট দিচ্ছেন 19 তাই দিন হ্যাঁ 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 দুটো 19 তারিখ তাহলে তাহলে দাঁড়ান তাহলে 28 আর 29 এই দুটোকে 19 তারিখ করুন ঠিক আছে 30 30 ডেকেছেন তো 30 ডেকেছেন আর 31 ডেকেছেন 31টা রাখুন এই দুটোকে 20 তারিখ করুন ঠিক আছে তারপর এটা 21st. Item number next 33, 21st. Next.
In 34, I
34.
Lordship, I am for the appellant in this matter.
am for the respondent.
আচ্ছা দাঁড়ান দাঁড়ান এক মিনিট
34.
I am for the respondent.
না ওই বিমান বাবু ওই কি নাম ডিসপ্লে বোর্ড ঠিকঠাক চলছে তো এবার দেখে নিন it is functioning the display
Yes, my lord. We have been following
Yes,
the
Lordship, the display board is correct.
It is correct.
It was showing all along.
you are for the
I am for
appellant
the appellant.
34 din
Lordship, this is a second half bill of the year 1989. Lordship, on the earlier occasion,
first of all learned counsels
Lordship,
one application being can 1 of 1997
My lord, all that has been disposed of by your lordship's order dated 12th of December
what I was about to
2025.
Okay.
My lord, all cans.
can 1 of
My lord,
1997
can 1 of 1997, can 2 of 2002, can 3 of 2007. My lord, I have the order with me. And
regard to can 1,
three disposed of
3 disposed
Lordship,
of.
in regard to can
Oh.
1, Lordship has passed the order dated January 9th, 2026.
My lord, in January 9, 2026, my lord, there was a correction of the order. My lord, this is the order of 9 January.
Yes, that is in respect of can 1.
thank you so there is no other hindrance
No, my lord.
Lordship, no. Lordship, kindly fix a date for hearing.
My lord, from January,
It was
my lord,
scheduled
this
to-
was, my lord,
learned counsels both
Lord.
of you are willing
my lord,
Lordship,
this
I
has
am
been-
willing.
from January, there was an occasion of marriage. So, my lord, we both agreed for,
Lordship,
from
it was
February,
scheduled
it is
to
not
appear
being
on
taken up, my
February.
lord. I am
Thereafter,
suffering a degree of,
let us
Yes,
let
my
us forget the past so now both the learned counsels are willing to proceed
Lordship, I am.
my lord, I am always ready and willing.
So,
My lord, I am led by Mr. Sukanta Chakraborty.
Lordship, and I am led
When-
by Mr. Shona
Lordship, my lord, lordship, kindly fix a date
when can it be taken up
this month.
As per Lordship's pleasure.
tomorrow
Lordship, tomorrow would be too soon.
which date
Lordship, 2 weeks time.
My lord, no,
No,
my
no.
lord, but from January it is, oh, my lord, I leave it to your lord.
today is 10th
Today is 10. Lordship, next week 17th.
17th
17th.
My lord,
positively
without any,
learned counsel
Lordship,
positively
Lordship positive.
um, have you gone through the record of the trial court and the first appellate court
yes,
have you gone through
yes, my lord.
the record of the trial court and the first appellate court have you gone through
Lordship, someone, my senior is here, Lordship.
what to
Mr. Shona Bhattacharya.
Oh, yes.
Kindly give me some
Mr. Bhattacharya, on your ground today
And he is coming for the first time.
one accommodation has already been sought for
from tomorrow, my lord, this bench that was not at all regular, my lord, we could not. That
But,
from today, yes. There will be no further. my lord.
when can this one be taken up
17 days. 17 August.
And I have not gone my lord, at all, my lord, fortnight, my lord.
what will this bench do
Fortnight,
during this period
I do not want to address your lordship. My lord, lordship has been seeing me, my lord, in court number 16. I was not ever unprepared, my lord. Otherwise, fortnight.
19th 20th
20th. 20th.
My lord, may
willing being unwilling
Lord, I was praying, my lord, for 27th or 28th.
no then in that case 24th Monday,
Friday, my lord is not sitting.
yes,
21st.
yes, 21st. 21st.
ওই একটু আমাকে order
Prior to that, go through the trial court record and the first appellate court record, including the documents.
all are here, my lord.
No, whether they are here or not.
কে দিয়েছে খুলেও দেখা হয়
কি বলে, হ্যাঁ হ্যাঁ নেই না item number 34 কত অর্ডারে যাই next date of hearing. Request of hearing, taken on the hearing of the appeal. And through the record, the appeal said application has been disposed of. Legal errors have been substituted. They are already on record. এটা তো order 41 rule 27 এইটাই কথা বলছিলাম। Then application for additional evidence, then can one of the record can one is not in the record. No, can 1 of 1997, old can number 5597 of 97.
My lord, lordship will kindly see, my lord, I have handed over the order of 12th of December 2020.
Yes, I'm going through the order dated 12th of December 2025. No.
Fine.
No.
My lord, my lord, lordship will kindly then take 9 January's order.
9 January. As per the direction of the earlier, as per the direction on the earlier occasion, a copy of the said application has been provided by the learned counsel representing the appellants, and the learned counsel representing the respondents admits that the said copies of the application being can of 1 of 1997. Let the copy of the said application be kept to the record. It also transfers on the record that white order dated at the original plaintiff respondent has been substituted by the present respondents, namely Bithi Banerjee, being the wife of Nipendranath Banerjee, since deceased, and Tirthankar Banerjee and Madhavi Sarkar, being the son and daughter of the said Nipendranath Banerjee. Then in that circumstance, can 1 of 1997 has been disposed of?
Yes, my lord.
Lordship, it has been.
As per the earlier order dated 9/1/2026, it transpires that white order dated 4/2/2000, 4/2/2000, 4th February 2000. The original plaintiff oblique respondent has been substituted by the present respondents, and Nipendranath, who is Nipendranath Banerjee?
My lord, Nipendranath Banerjee.
Since this is through that application, the substitution of Nipendranath Banerjee was sought for.
Yes.
Hello, sentence term. It transpires that the 4/2/2000 original plaintiff stroke respondent, namely Nipendranath Banerjee, has been substituted by his legal heirs. As such, the said application being can 1 of 1997 has been disposed of. Full stop. আচ্ছা এইগুলো can 2 of 2002 bearing the old can number 4760 of 2002, being an application Learned counsels, do you have the application?
Lordship, that has been,
Can
that is
2
the
of
application
2002.
for
Order
additional
41, Rule 27.
Lordship.
Order 41, Rule 27.
পেপার বুকে সেকেন্ড পেপার বুকে সব
হ্যাঁ হয়ে গেছে ওটা হয়ে গেল নেক্সট প্যারাগ্রাফ the application being can 2 of 2002 bearing the old
সুবিধা হলো আরো
can number
কিন্তু মানে
4760
ফরম্যাট নয়
মানে old number can 4760 of 2002 being an application under order 41 rule 27 of the code of civil procedure, the said application will be taken up along with the hearing. Full stop. So it has not been disposed of. It is still pending. Can do. Order 41 rule 27.
That has to be final hearing of the appeal.
Along with the hearing.
It was my understanding that on 9th January, it has been disposed. 9th January.
Cannot be disposed of.
Obliged.
9th January. No. White 9th January, the order dated 9th January 2026. It has been stated that can 1 of 1997 has been disposed of. And now as regards to can 2, that is under order 41 rule 27. That will be taken up along with the hearing.
There is no observation to that effect.
There is no observation to that effect. No, there is.
But it has been recorded in order
This is an application seeking leave to provide additional evidence. As the said application is for additional evidence, the same shall be taken up along with the hearing of the appeal.
Yes, that is sufficient.
তাহলে ওইটা পেন্ডিং আছে ক্যান 2 of 2002 টা পেন্ডিং আছে তারপর ক্যান 3 seeking a substitution from the level of the said application has been disposed of. Can 3 also disposed of. Wide order dated 12/12/2025. It transpires. লিখে দিন নাহলে ওই যে যেহেতু এখানে লিখছে না 2007 has been disposed of being an application for substitution of the sole respondent has been disposed of and the legal heirs of the sole respondent have been substituted. Learned counsel, the legal heirs of the sole respondent, they have been substituted.
Yes, my lord. By order dated 4th February 2000, my lord, as recorded in the paper.
As such, there is only one application pending, that is can 2 of 2002, bearing old number can 4760 of 2002. তারপরে on consent of both sides, that will be taken up along with the hearing of the appeal. ওই যে application type. ঠিক আছে on consent.
My lord, only one request. Lord, you will kindly record that, not that consent, my lord, as the court direction.
আচ্ছা তাহলে দিন লিখুন learned counsel representing the appellants seeks an accommodation for fortnight. Full stop. The prayer is considered. Let the matter appear on 21st of August 2026 under the heading hearing. In the meantime, learned counsel go through the trial court record on the first.
May I get back that
Yes.
The orders, and lordship,
Of course.
If my lord kindly give some precedence for the hearing, my lord. Otherwise,
তাহলে শুনুন তাহলে ওই at the top করে দেবেন 21st of August 2026 at the top.
oblige, my lord. Thank you.
Cooperation from that end is required.
Yes.
Otherwise,
usually I appear, my lord has seen my lord in 16.
No. Hearing also.
My lord, he will start afresh. He's a
Being
out
a
of
regular
21 to
bench,
20.
being a regular bench,
Yes,
we'll have to start afresh.
yes, my lord.
Nil. Next. আচ্ছা কি বলে এখানে ওই ওই যেগুলো ডিসপোজ অফ হয়ে যাচ্ছে না এগুলো কিন্তু সরে যাবে হ্যাঁ 35 হ্যাঁ সেম অর্ডার হবে 35 এটা ওই কবে কবে ডেট হলো দেখুন তো দুটো হয়ে গেছে তাহলে এটা 24th of August 35টা হলো 24th of August তারপর হ্যাঁ 36 ওই 24th of August তারপর আপনি নেবেন না উনি নেবেন কে নেবেন আচ্ছা ঠিক 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 আছে থ্যাংক ইউ নিন তারপর 37 জোরে না না ওইগুলো করুন 37 as none is representing either the appellants or respondents the matter can be taken up ওই 20 কত 24th next 25th হচ্ছে টিউসডে এটা 25th আসছে নেক্সট আর একটা 38 হলো 39 ও 37 হলো আচ্ছা 38 সেম অর্ডার ডেটটা শুধু দেখে নেবেন লাস্ট হচ্ছে 39 এটা এটা ডেট 26th ঠিক আছে 26 হচ্ছে ওয়েডনেসডে ঠিক আছে নিন হ্যাঁ নেক্সট অ্যাসাইন ম্যাটার ক্রিমিনাল ডাকুন Forty. None is representing the petitioner. Full stop. On the paragraph on the earlier occasion, on the earlier occasion, that is on 24/7/2026, none had represented the petitioner. Full stop. In such circumstance, let the matter appear on 13/8/2026. Next.
Item number 41.
একই ব্যক্তি দেখছি কি সবকটা একই 40, 41, 42 অভিষেক চামারিয়া 43, 44 অভিষেক চামারিয়া একই ব্যক্তি একই মানে পিটিশনার একই দেখুন দেখুন দিন 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 দেখুন এটা কত আইটেম নাম্বার 41 2491 তাহলে একটা একটা করে কোন 41 আগের অর্ডারটা কি হয়েছে none is representing the petitioner on the earlier occasion, that is on 24/7/2026, none had represented the petitioner. Full stop. In such circumstance, let the matter appear on 13 একটা করে দেখে দিই সেমি অর্ডার হবে তারপর নেক্সট 42 ডেটটা দেখে নিন একই 24/7 সেম অর্ডার সেম ডেট সেম ডেট 24/7 none appeared same order
Item number 44.
same order দেখে নিন ডেট সেম অর্ডার সবকটাই থাকছে ওই 13th অগস্ট বৃহস্পতিবার নেক্সট ওইরকম রাখলে হবে না কন্টেস্টেড অ্যাপ্লিকেশন বলে আইটেম নাম্বার 45 উইথ 46 47
Item number 45 with 46 with 47, 47.
Honored Council, which one do you have? Item number
70, 71 and 73. One is 71, my lord. I'm terribly suffering, my lord. A blanket, my lord. Order of. I'm waiting.
ডাকুন নেক্সট ডাকুন একটা একটা করে দাঁড়ান 45 46 47 কি বলে none is representing 45 with 46 47 none is representing the petitioner as such the matter cannot be proceeded let the matter appear on 14th of August 2026 next রেকর্ড গুলো দেখে নিন নিয়ে নিন Learned counsels, when the bench is not available,
Yes.
there's grievance.
Then a very rush.
Then there's rush.
Bench
Bench
is
is,
willing to
willing
discuss
to
the
take-
matter. Nobody found
nobody's
present. It is unfortunate.
At least the petitioners
Yes,
should
yes,
appear.
yes, yes. And it is not no on all on the sudden your
No.
lordship's seat today for the whole.
This has been intimated, I think, since Saturday.
But everyone knows that 8 judges have been elevated from the bar. So it is not unknown to any member of our bar.
Only one chance will be given. Thereafter,
My lord,
chances won't be given.
Long pending, huge pendency, my lord. And yesterday I will come up with some CO.
Let few be disposed of thereafter. একটা একটা করে ডাকুন, একটা একটা করে ডাকুন। দাঁড়ান দাঁড়ান দাঁড়ান। একটা একটা করে 49 লাস্টেরটা ডেট কি ছিল লাস্টের? ওই 14th অগস্ট। লাস্টেরটা মানে 14th অগস্ট ছিল ডেট দেওয়া হয়েছে। 14th, এইটাও সেম করুন 14th। হ্যাঁ, আর 48টা বলছি 45, 46, 47 14th অগস্ট, 48 14th অগস্ট। কারণ হচ্ছে ধরুন যদি আজকে আপলোড না হয় কালকে তো আপলোড হবেই, আপলোড হলে দেখতে হবে তোদের, সেই জন্য 14th অগস্ট দিচ্ছি। কালকের মধ্যে আপলোড করে দেবেন কিন্তু, বুঝেছো? কটা অব্দি থাকছে না দেখছি আমি, কতগুলো কি পারি ডিকটেশন দিয়ে। 48 হলো 14th, তারপর 49 রাখুন। फोर्टीन्थ করুন। নেক্সট 14th করুন। নেক্সট ভোট করুন। আরে কি দাঁড়ান 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 দাঁড়ান, ও হবে না। 50 ডাকুন। এ কি কথা, মুখে বলবেন সঙ্গে সঙ্গে বোর্ড কেলে আপলোড হবে। 50 সেম। নেক্সট 51 বোর্ডটা তো উনি কন্ট্রোল করছেন, আপনি কেলে আচ্ছা কেলে ডাকবেন একজন কল আচ্ছা ঠিক আছে, ওটা খেয়াল রাখবেন। সেম অর্ডার হচ্ছে 51 14 থাকছে। তারপর নেক্সট
My lord, 52, my lord. I am for the petitioner in this case, my lord. What has happened, my lord? Long back, my lord, I have served. My lord, there was a direction for service, my lord. My lord, kindly grants me, my lord, at least with 2 weeks time, my lord. My lord, there are so many, my lord, opposite parties are there, my lord. My lord, I have to serve afresh.
ওই কেলে রেকর্ডটা ওদিন 52
52, my lord.
রেকর্ডটা
My lord, today itself, my lord, I don't have a brief also, my lord. I am sorry for that, my lord. Extremely sorry.
No, at least the learned counsel should attend.
Yes, that's true. That's
and should express what is the difficulty.
This is also old matter, 2019.
2019, one line.
19. This matter was running in the list, my lord, since long, my lord, but an interim order was passed by His Lordship Justice Sabyasachi Bhattacharya, my lord, and His Lordship in the single bench.
The petitioners have made out a prima facie case as to whether the trial court acted without jurisdiction in refusing the petitioner's prayer for amendment of the plaint. You had sought for amendment of the plaint
Yes.
to incorporate the previous bag numbers in respect of the suit plots. Means you want to incorporate the CS or RS?
My lord, that I have to check the brief, my lord. Otherwise, my lord, I cannot.
Without
And only, my
considering-
lord, change of DAG number, my lord. Same DAG number followed from the new, my lord, record of rights.
In the plaint, either the LR or the RS is there, you want to incorporate the CS one.
CS also, my lord.
If RS is there, you want to incorporate the CS, and if LR is there, you want to incorporate RS.
Yes.
CS and RS. That won't change the nature and character of the suit.
That will not, my lord. No way, my lord.
Without considering that the knowledge of the
Same
petitioner
plot.
pertaining to such proposed amendment was derived during pendency of the suit. Accordingly, the petitioners are directed to serve copies of this revisional application bearing CO 994 of 2019 on the opposite parties, along with a notice indicating this revisional application will appear for hearing as a contested application in the monthly combined list of cases for the month of May. So
Well, that I have checked from, my lord, from my device, my lord, that order was there. My lord, what has happened, my lord, at that point of time, my lord, I have served. But, my lord, I have missed the brief. Subsequently, my lord, I have made it xerox from one of the learned friend of the learned code appearing with the learned code below, my lord. Now I have a brief, my lord. That is no difficulty, my lord. But I have to serve once again, my lord, to the opposite party. Otherwise, my lord.
You are the advocate on record.
Yes, my lord, I am the advocate on record.
Name. 52. The learned advocate representing the petitioners submits that on earlier occasion the petitioners were directed to serve copies of this revisional application upon the opposite parties, and at that relevant point of time it was served, but years have passed by. Several years have passed by. In such circumstance, the learned counsel submits that he intends to serve the copy of the petition upon the opposite parties afresh, full stop. Considered the prayer of the learned counsel. আচ্ছা ওখানে বলে দিন and seeks an accommodation for
At least, my lord, 2 weeks is needed, my lord. I have to serve Bankura, my lord. Most of the, my lord, opposite
2 weeks.
2 weeks, my lord. Kindly keep it midweek of, my lord, first week of September. Any convenient type of time of your lordships, so that service can be effected.
27th.
27th, my lord, I have some difficulty. May I kindly keep it next week, my lord, any day, my lord.
First of September.
1st of September.
Seeks an accommodation for this month. ঠিক আছে? For seeks an accommodation for 3 weeks. Seeks an accommodation for 3 weeks. ঠিক আছে? Consider the submission of the learned counsel. ওটা ওনার prayer হলো 3 weeks এর. Seeks an accommodation for 3 weeks. হলো? In such circumstance, the prayer is allowed. Let the copy of the revisional application bearing CO 994 of 2019 be served upon the opposite parties along with a notice indicating that this revisional application will be taken up for hearing as a contested application on 1/9/2026, 1st of September 2026. File an affidavit and to file an affidavit
On the
to that
next date.
effect. To that effect on the next date. Full stop. There will be stay of all further proceedings and title suit number ato pending with the civil judge senior division. ঠিক আছে।
এটা বলতে গেলাম ভুলে গেলাম।
Anything more to be submitted?
What? Forgot Milord what? Very well, Milord. Keep it on Milord 1st September.
1st September. Next.
Oh, sorry, Milord. Can I get a Milord server copy within Milord 1 to 2 days?
Tomorrow, by tomorrow, you will get the server copy.
Very well. Get.
কালকের মধ্যে আপলোড হয়ে যাবে। Next. No, 53. Same order. ওই ডেট কত হচ্ছে? 17th 14th দিয়ে দিন। নেক্সট। ফোরটিনতে কতগুলো হলো? কটা হয়েছে? তাহলে এটা তাহলে 17th, হ্যাঁ 14th তাহলে চেঞ্জ করে দিন ডেট 17th। 53 থেকে 17, 53, 17, 54, same order 17. Next. 55, same order 17. ফাইল আছে তো, রেকর্ড আছে তো, দেখে নিচ্ছেন তো? নেক্সট। নেক্সট। Same order 17th. Next. Same order 17th. Next. 58, same order 17th. ছটা হলে বলবেন। 59.
I am praying for the petitioner.
Petitioner. Item number
59.
59. 59 এর ফাইলটা।
Well, also I am praying for adjournment today.
Are you the advocate on record?
I'm led by Mr. HON'BLE.
নাম দিয়ে নেবেন, ঠিক আছে? শুধু ওনার নামই নেবেন, বুঝলেন? Give your name only.
Okay.
Not the name of others.
Auditor.
59 হচ্ছে CO 1594
petitioner.
of 2019. When can you serve and come?
So 4 weeks, but 2 weeks time, sir, Your Lordship.
Without jurisdiction, the petition is up to amendment to introduce a relief of specific performance of a contract, despite the basic ingredients of such relief being available in the original claim filed in the trial court itself. According, the petition is directed to serve copies of revision or application on the opposite parties, intimating the opposite parties that the matter will appear as a contested appeal in the monthly. Demanding the petitioner will file an affidavit of service on the next date of hearing. Learned advocate representing the petitioner, it was 59. The learned advocate representing the petitioner seeks an accommodation, full stop. You will have to serve afresh.
Yes,
Learned
yes, my
counsel.
lord.
When can you come back? After service, along with affidavit of service?
Your Lordship, 4 weeks. 4 weeks.
4 weeks. The address is Lake Road, Kolkata, Benting Street, Kolkata, Jadavpur CIT Market, Kolkata. I don't think it will take more than a week.
That's Lordship.
According to circumstance, you pray.
Okay, Lordship.
Don't pray as a general.
2 weeks, Lordship.
The learned advocate representing the petitioner seeks an accommodation for fortnight to serve the notice upon the opposite parties. Full stop. The prayer is considered. Full stop. Let the matter appear on 20th of August 2026 under the heading contested application. Full stop. Let affidavit of service be filed on that date. You serve upon all the opposite parties and file the affidavit of service.
Yes. Must oblige.
20th August.
Must oblige.
Next. Item number 60. None is representing the petitioner. Date. কত চলছিল সে 17 না কত কি 17 তারিখ চলছিল তো 6টা হয়েছে তো তাহলে এটা 18th করুন 18th of August 6 next
61. I appear for the petitioner.
For the petitioner.
There is an interim order which has been continued until further orders.
Stay.
Stay. Respondent appeared on last occasion and sought for accommodation. So I can give him a notice and come back.
That is a few years ago.
Yes, this is a application allowing an amended claim by West Bengal State Electricity Corporation, allowing which the claim is time barred, and also the amendment was allowed after the hearing had commenced. So there was no explanation and there's no reason. That's why it was stayed. And then my learned friend was asked to clarify that he sought for time, so it was the order was continued. So I am prepared. I can argue any day, but I want to. I'll serve a notice and come back.
You're for the
petitioner.
Petitioner.
Yes.
Measures Shobha Ispat.
Shobha Ispat. The order, I have a copy of the first interim order was passed on 11/12/2019. And
whereby stay was granted.
And it was continued until further orders by the order dated 11th August 2022.
One minute. কি বলে এই শুনুন এদিকে আসুন এরকম খুলে যাচ্ছে সব ট্যাগ গুলো সব খুলে যাচ্ছে পুরো অর্ডার শিট খোলা বুঝেছেন অর্ডার শিট খোলা এবার একটু দিয়ে দিচ্ছি, দিলে বই করে নেবেন। হ্যাঁ, you are mentioning order.
May I hand over a copy, my lord?
No, you mentioned order dated
First order was
11/12/2019.
11/12/2019. Yes.
Claim of WBSEB State Electricity Company Limited was 9 crore.
9 lakh.
No.
Sorry,
9 crore 8 lakh.
9 crore 8 lakh.
9 crore 8 lakh
It was
78,000.
It was enhanced from 7 crore to 9 crore. That amendment was allowed. The additional claim, there was no explanation.
Originally
Yes.
it was 7 crores 25,000.
Yes, and it was
88,202.
yes.
And delayed payment, an arguable case is made out by the defendant petitioner in as much as once the claim was for recovery of 7 crore as outstanding dues. The amendment of the plaintiff claiming rupees 9 delayed payment surcharge. Oh, it was enhanced on the ground of delayed payment surcharge.
No particulars were given, and also there was no explanation why it was not claimed at the first time. And when it was sought to be introduced by way of amendment, it has become a time-barred claim. So first point is that once, if you want to amend an application after hearing, after the amendment of CPC, there has to be a explanation. There was no explanation. Secondly, to incorporate a time-barred claim. These are the two main points.
There should be a stay of all further proceedings. So till now there is a stay.
Now that is continued. My kindly see, my lord, the order dated 11th August 2022.
11th. Yes, on the prayer of the Senate Council with opposite party hearing. Oh. Hearing revision is adjourned. Interim order is extended to the disposal. Interim order is extended till the disposal of the revisional application.
And before that, there is an order where Mr. S.S. Cole appeared in court for accommodation. That is dated 19th April 2022. So I can serve another.
Upon Mr. S.S. Cole.
Yes.
Nin. The learned counsel representing the petitioner submits that long ago the matter was taken up for hearing, and since the year 2022 it has not been taken up for hearing. In such circumstance, the learned counsel has been candid enough to pray candid enough praying for serving notice upon the learned counsel representing the opposite party that is West Bengal State Electricity Company Limited, afresh. Full stop. Learned counsel, when can it be fixed?
If your lordship so pleases, if your lordship fixes it in first week of September or late August, I have. I'll leave it to your lordship.
Twentieth 20. Today's 10th.
Well, give me a minute. Very well, 20th.
Let the matter appear on 20th of August. Full stop. The petitioner is directed to serve copy of the notice afresh upon the learned counsel representing the opposite party, and to file an affidavit in this regard on the next date. Let the matter appear.
Mr. Mr. Cole, he was appearing. Mr. Cole,
Mr. S.S. Cole, who is representing the opposite party, West Bengal State Electricity Development Company Limited. Company Limited. No, West Bengal State Electricity
think distribution company, WBCDEDCL,
In the-
distribution company limited.
In the application, it is not mentioned.
Oh, actually, I am fighting with them. They are illegally charging me in one of my residential
তাহলে
sites.
শুনুন, ওটা
No, but let it remain, whatever is there.
Electricity Company Limited,
Yes.
bracketed WBSEDCL, T for distribution, DCL, and to file an affidavit on the next date. Let the matter appear under the heading contested application. ওই ডেটটা কবে, 20th, তাই তো, 20 তারিখ, 20th August। আচ্ছা, এই অর্ডার শিটগুলো ঠিক করে ট্যাগ করে দিন। নেক্সট,
I'm grateful, my lord.
নেক্সট,
Chief, I'm on behalf of the respondent.
My lord, may I submit, Lordship? In this matter, I'm appealing for the opposite party. Lordship, the order impugned after the order impugned.
He is a senior.
Yes, my lord. After the passing of the order impugned, there was a degree, and that has been challenged before the Honorable High Court, and your Lordship has heard this matter presided over before the bench in court number 16 with Honorable Justice.
Heard by this bench.
Heard by your Lordship along with Honorable Justice Sobhasasi Bhattacharya, Lordship, because after passing of the impugned order, the suit was finally decreed. So the matter has become infructuous, Lordship.
That will have to be mentioned by the petitioners.
My lord, absolutely. But so far, your Lordship can remember, if your Lordship remember, that matter was heard with your Lordship last week, my lord. And your Lordship was presiding in court number 16, Lordship.
Learned Counsel, several matters take place on a day.
Yeah, absolutely, my lord, absolutely correct.
Yes, okay.
That is why, my lord, probably they are not appearing. Petitioner is not appearing.
None is representing the petitioner, while the respondent. None is representing the petitioner, while the respondent is being represented. Full
My
stop.
lord, kindly record that the suit is decreed on 30th December 2021. My submission may be recorded.
The learned advocate, the learned counsel representing the respondent submits that the suit being title suit number.
My lord, it is a matrimonial
suit.
So it is not.
Yes, against an order of.
Yes.
My lord, this revisional application is arising out of.
Arising out of interlocutory order during the examination, cross-examination of the DW1, my lord.
Maintenance pendency light.
No, my lord, this is that the allegation, my lord, so far I recollect, the allegation probably that they were not given the chance for the recalling of the witness, my lord. That was perhaps, if I am subject to correction, my lord. So against that order, they have challenged with your lordship this impugned revisional application, but subsequently thereafter, my lord, the matter was heard and the decree was passed, and that decree itself challenged before the Honorable High Court in FA number 100 and 2022.
Learned counsel, come on the next day in support of your contention with the document.
As your lordship. Absolutely.
Let the matter appear on 18th. Let the matter appear on 18th. Come on that day.
My lord, instead of 18th, my lord, instead of 18th, cannot be on 21st or 22nd, my lord.
21st.
As you.
The learned counsel representing the respondent seeks an accommodation for a fortnight. Let the matter appear on 21st of August. 21st
So far, the lordship kindly record that I'll produce the copy of the decree, my lord.
That is up to you, learned counsel.
My lord,
on that day you produce.
My lord. Lordship.
It will be taken note of on that day.
I'm grateful, my lord.
Next. নামটা নিয়ে নেবেন। 63 same order. Date কত হচ্ছিল? 17th. দেখে নেবেন কিন্তু নাম্বার গুলো দেখে নেবেন কোনটা কি হচ্ছে।
Number 64. Number 65. Item number 66. Item number 67. Item number 68. Item number 69.
My lord, whenever your lordships, my lord,
Comfort the petitioner.
Learning Council.
রেকর্ড তো এখানেই ছিল। অনেকবার জজ সাহেবের টেবিলে উঠেছে এটা। হুম CO 2814 মানে সে
Item number 70 was representing petition.
both petitioner, both petitioner. In both the matter, I am for the opposite party.
My instruction is to pray for time today. Salil Kumar Bhai. My senior is the advocate. I had a confusion as to if my senior is the advocate of record. Bill for accommodation. For this week.
Not this week. Man, definitely. He can pray before your lords. My lord, thing is this, my lord. Execution proceeding is pending at the instance of suit for, my lord, declaration injunction. It is a bit. I am the plaintiff. I am the owner, co-owner, landlord. And they also landlord in respective portion. But there were some, my lord, mistakes in the record of rights. And so for that reason, this declaration was sought for, and the suit was decreed. And my lord, the some of the defendant not appeared, and some of the defendant they also co-owner in respect the property divided. The property divided. Several coming from single ancestors. Inherited.
Now, you have cheap partition.
Yes. By meets and bound.
Registered partition deed.
Yes. Registered partition deed. Now what happened, my lord? There was some. It is before the trial court. It is, my lord, after obtaining ex parte decree, partly ex parte in respect of this against this petitioner, and contested against all. My lord, decree has been passed. It is in the execution. Execution, they took plea. Yes. No first appeal. Since it is ex parte, they, my lord, filed one independent suit. One independent suit. No, that independent suit goes dismissed. And when I filed that is dismissed. Why I can't say that? Why that is dismissed? But now we are against the order arising from this title execution case. Both the two application. Well, today it is not possible. Kindly keep it tomorrow.
I have instructed to seek for a week's accommodation. That is not possible. Yes.
My lord, sum and substance. My lord, sum and substance of their dispute is one of the non-attending defendant who died. Non-attending. Who, yes, never appeared. So, one defendant not appeared despite summons, receipt of summons. Yes. Yes, not my property. She enjoyed some property from the common ancestor. It is, my lord, dispute is, my lord, since. My lord, if you. Yes, yes.
It has been, according to you,
Yes.
it has been partitioned by mutual bound to register deed, I think.
Yes.
Register deed.
Yes.
We have been allotted some portion, they have been allotted some portion. Now, the dispute.
There,
And,
there,
against, what the plaintiff
there,
has said,
there were some wrong recording in the yes, in the record of rights. Yes, record of rights at present, RS. No, no, LR, sorry. LR record of rights, there are some irregularities over my portion, over my allotted portion, that give arise to file the suit by the plaintiff opposite party. In the same said suit, the co-owners who were the co-owners made party. One of the co-owners was, my lord, the deceased, my lord, who never appeared despite receipt of summons. So, just for their knowledge, it is not their property, it is my portion.
why that person was made a party?
My lord,
They don't have any interest. Why that person was made a
my lord, they were involved in the, my lord, they enjoyed the property from the common ancestor. That was allotment, the allotment was done. Somehow they were made party. But if, my lord, I, yes, yes. No, not, it is not, it is not the luxury, because Malati Dhali, so Malati Dhali is the plaintiff, my lord, the one of the defendant, my lord, who died, my lord. She was not represented. As per your lordship direction for ascertaining, my lord, the next course of action, my lord.
There won't be any adjournment. Any other person to appear apart from them?
No, it is there. He is he is representing petitioner.
Has been made a party.
No, probably not. Not. Shobhan Dhali. Yes. 1513. Opposite party decree holders. Same. It is at the instance of the. Well, they will explain, my lord, one after another proceeding just to thwart the execution proceeding. Contention is, my lord, the suit is abated because decree was passed in the name of a deceased person who never appeared. একুশ তারিখ শুক্রবার 14. No, 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 no. But next one matter, my lord, 73.